The first issue that I'd like to address is this morning I brought a copy and showed Mr. Kane of what is Michigan Penal Code 750.84. That is the relevant statute the defendant was ultimately convicted of in Michigan. That's the lesser included offense.
What is the name of the offense?
It is entitled Assault with the Intent to Do Great Bodily Harm Less Than Murder, assault by strangulation or suffocation, strangulation or suffocation defined, other violation out of same conduct.
Okay.
And I have a copy here if Your Honor wants to see it. I printed it from the Michigan Legislature website.
You can bring it down. I'll hang on to it. What's the issue?
So the issue is Mr. Kane thinks that that is not admissible evidence. I said, can I use it as a demonstrative? He then said no. And I said, fine, but can we agree that in the instructions that Your Honor will ultimately instruct the jury that and I'm reading from the proposed instructions that I previously submitted under final instructions in penalty proceedings 7.11, it says the aggravating factors alleged by the state are, 1, Matthew Terry was previously convicted of a felony involving the use or threat of violence to another person. And then it says, the crime of assault with intent to do great bodily harm less than murder is a felony involving the use or threat of violence to another person. To me, that is a legal conclusion that Your Honor is telling the jury. This crime is a violent felony. Whether or not the state has proven that he's been convicted of it is a separate question. That's why I'm putting in the certified copy of conviction. But in the abundance of precaution, I am ready to have the prosecutor explain basically what the elements of the crime in Michigan are, in case we have to then instruct the jury what the elements of the corresponding crime here in Florida is, which I would assert is aggravated battery. So if we have to go that route, because the defense does not want Your Honor to tell them that as a matter of law, assault with intent to do great bodily harm less than murder is a felony involving the use or threat of violence to another person, which
It's not a finding they have to make?
Thank you, Your Honor. It is a jury question.
I don't know. I'm posing it as a question.
I think it
and
is
so
a-
I see now that that's the defense position, but that was my initial thought as well. I mean, I need to be very careful, making findings or doing anything like that.
Your Honor, I'd ask you to read the proposed instruction, but this is taken from the standard instructions, and this is a separate sentence that does not say you must decide if assault with intent to do great bodily harm is a felony. It says it is. It's you telling them that it is. Just like in aggravated, like in battery on a law enforcement officer, there's an instruction, I'd have to read it, but it basically tells them they are a law enforcement officer.
What the state is asking this court to do is to adopt what they expect to be testimony of an out-of-state lawyer regarding out-of-state law. The court, upon hearing that, to take essentially judicial notice of a fact that the state has to prove by allowing that into the jury instructions. That is usurping the jury function.
I got to admit, Mr. Diaz, it scares me.
Judge, to be clear, I wasn't asking for that. What I was ready to do was to put the prosecutor on to show the jury the statute, to let her explain what the statute means in Michigan as a prosecutor in Michigan. The defense does not want me to do that. So I said, fine, if you don't want me to have her come here and testify to what Michigan law is and how Michigan law works, then are you agreeing that the judge is going to read an instruction that says definitively that the crime that appears on the certified copy of conviction is a violent felony? And if they're just going to agree that Your Honor is going to tell them that fact, then I don't need to have the prosecutor interpret the law.
All right, well, let's go back to if, and Mr. Kane, I don't disagree, and I'm very cautious to make any findings and assert the jury's role, but if they have to prove it, like your position is, what's the objection to them calling the prosecutor to testify to what the law is in Michigan so that the jury can have all of the facts and ultimately make that decision?
Because the certified record of the conviction, coupled with the testimony of Michelle Rogers, is what the jury weighs. Bringing in an out-of-state lawyer to talk about elements is irrelevant. There is nothing in the jury instructions that talks about elements of an offense, except that it's the use or threat of use of violence against a person. So that the jury instructions lay out the elements of the aggravator, not some Michigan lawyer.
Does anybody have any authority on this? And this can't be the first time this has come up in a penalty phase regarding a prior.
I do not have any case law, Your Honor. I told Mr. Kane repeatedly what my intention was in calling Ms. Gallagher. He had never expressed any objection to her coming to interpret Michigan law to explain that the title of an offense involves the use of violence or the threat of violence. And so I did not come prepared for this. And to me, this is no different than in jury instruction 8.11, battery on a law enforcement officer, where the last sentence reads, the court now instructs you that, and you enter the official name of the victim, meaning a Hillsborough County Sheriff's deputy, for example, is a law enforcement officer. That's a matter of law. Sheriff's deputies are law enforcement officers. Now, whether the state has proven that the person who took the stand and testified is a sheriff's deputy, whether or not we've proven they were acting in the lawful performance of their duties, that's part of the elements of the offense. But the sentence that Your Honor would read from the instructions is definitive. It's you telling them that this particular crime is a violent felony.
All right, I'm going to have to take a look. I'm going to have to look at other cases that have been heard in this circuit and see how this was handled, what the instructions were, and I can do all of that. I can ask Ms. Spradley, you've been involved in a lot of these, and whether this issue has come up before in front of Judge Ward, Judge Sisko, and how it was addressed, or I can take a lengthy break and I can go get the jury instructions from prior death penalty proceedings, penalty phases, and we'll reconvene in a little while.
Yes, and also when it comes to Florida law enforcement officers, obviously this court can recognize whether or not a Hillsborough County Sheriff's deputy is a sworn law enforcement officer. We're not talking about that. We're talking about out-of-state law. I don't think, and whether or not the elements of an offense in Michigan are relevant to what the state has to prove in terms of what the jury instructions require. The jury instructions are very straightforward about what a prior violent felony is. We don't have an objection to the certified conviction of that from Michigan.
But what is the jury weighing against? Then Mr. Diaz is faced with the having to argue that it constitutes a violent felony. They have to make that finding that it is a violent felony, and
based on the facts based on what they believe of Michelle Rogers. It's Michelle Rogers. In other words, what happens is if this court says that aggravated assault with intent to cause great bodily harm with the use of a weapon is a prior violent felony, what's the purpose of calling Michelle Rogers? If all we need is just Alicia Gallagher to come down here and testify to the elements of what that means, and you have the certified conviction, then Michelle Rogers' testimony is irrelevant. Because the court's taking judicial notice of the fact that it's a violent felony against a person.
Wait.
Right?
Excuse me.
Okay? You need a break?
Sorry, I'm
No, it's all right. You need water?
I have some, thank you.
All right. Let me know if you need a break.
I'm good.
All right.
Sorry.
Sorry. So it's not all relevant, right? What's relevant? Are they weighing Michelle Rogers' testimony during deliberations on whether or not some violent act was committed upon her? Because they're not going to do that if this court takes that function away from them and tells them, by operation of the law, this conviction is a violent felony against a person. Michelle Rogers' testimony factors into whether or not that aggravating factor has been proven. And we're asking this court to allow the jury to weigh her testimony and determine whether or not that aggravating factor has been proven, and not taking judicial notice of it by some comparative elements test.
Judge, I am at no point going to say the words judicial notice. I have at no point said the word judicial notice. I came here with the intention of putting on testimony. Mr. Kane does not want me to put on that testimony, so I'm now clarifying that it's my belief that under the standard instructions, you are going to tell them as a matter of law what the circumstances are. And so I don't want to have this debate later after Ms. Gallagher has gotten on a plane and left back to Michigan. I am happy to have her say, this is a crime in the state of Michigan, this is a felony that involves the use of violence, because she has to define what assault is in the state of Michigan. She has to talk about what assault is. And I would point out the fact that in the state of Florida, for example, battery is not always actually a forcible felony, whereas assault is. And Michigan uses assault differently than the state of Florida uses the word assault. And so I think someone needs to explain that to a jury. However, if the defense doesn't want that to happen, I am happy to just have you read the standard instruction and tell them that the certified copy, the thing that says on the certified copy, is a forcible felony, and I'll just bypass all of that.
Well, I'm inclined to go the route with allowing the APA, I guess that's what,
Assistant prosecuting attorney.
Prosecuting attorney, testify regarding the law and let the jury ultimately make that decision. I'm hesitant to instruct them, just bypass everything and me make the decision that it is a violent felony and read the instruction as you're suggesting in the alternative.
That's the standard instruction. I will show you the book.
But somebody has to make a determination as to whether it is a violent felony. Here we have the issue of, if it was a Florida prior, it would be easy. But we have to compare it to Michigan law, and that's where I don't know if that's a jury question or not, as to whether it qualifies as
But that's not the way the standard instruction is written. The standard instruction, I'm reading it directly out of the West Florida statutes. 2, defendant was previously convicted of a felony involving the use, threat of, violence to another person. Period. And then it says 2A or 2B as applicable. 2A is the crime of previous crime is a capital felony. That's it. So if it was murder, the crime of murder in the first degree is a capital felony. The second one is B, the crime of previous crime is a felony involving the use or threat of violence to another person. That is, Your Honor, telling them that as a matter of law, that is the situation. That is the standard instruction.
Okay, give me a minute. Yes, there has to be evidence of that in order for me to give it. In fact,
And
the
evidence
italicized says
the evidence is the certified copy of conviction. I don't actually have to bring the prosecutor. I could simply admit the certified copy of conviction. It could say, for example, murder in the first degree, and then Your Honor would have to give, for example, the crime of murder in the first degree is a capital felony.
But here, the certified copy of conviction says what? Assault with intent to do great bodily harm, and there was more to it. What specifically does it say?
The instruction of the certified
The
copy.
certified copy. What is the conviction for? Because I asked you what the charge was.
Well, I'll show it to Your Honor because we blacked it out because it said the lesser included of. So we took out the lesser included of. It says assault with intent to do great bodily harm, less than murder, 750.84 as the Michigan Penal Code.
What do you propose is the comparable charge in Florida?
Aggravated battery.
And your position is if Mr. Terry had a prior aggravated battery, that all we would do is include that, well, assuming you introduced evidence, which is the certified copy of conviction in Florida.
Assuming I had a Florida certified copy of conviction that said the defendant had previously been convicted of aggravated battery under either theory, deadly weapon or great bodily harm, but in this case, great bodily harm, because that's what the charge is there. You would read the crime of aggravated battery, great bodily harm, is a crime involving the use of force or threat of force, of violence, use of violence.
All right.
We would not be having this discussion if that were the case.
I'm being told that's exactly what Judge Sisko did in the Ronnie O'Neill case.
Judge,
Yes, Ms. Bradley.
In Mr. O'Neill's case, he did not have prior violent felonies. They were contemporaneous violent. They were from the case itself. So it was additional charges of attempted murder and aggravated child abuse and 2 deceased victims.
But once the jury convicted him in the guilt phase of those
Yes.
were included in the penalty phase instruction,
Yes.
just the way the state is proposing that I include the prior Michigan felony in this case.
Because it was a Florida law and they had done the conviction during the course. It wasn't a prior either from Florida or from another state. So that's the distinction that Mr. Kane is making in that.
Well, I hear it, but as long as it appears that the Michigan crime is a prior violent felony, what was the language of the?
Was convicted of a felony involving the use or threat of violence to another person.
And Mr. Diaz, you're comfortable with me making that finding, not the jury making that finding?
Judge, I don't know that you're making a finding, but you're reading an instruction, and that's what the instruction is telling the jury. It's telling them that it is, not that you
Well,
can.
somebody, in order to instruct the jury that it is, somebody has to decide first that it is.
I understand, Your Honor, which is why.
You're comfortable with me deciding that it is, so then I can instruct the jury that it is.
No, Your Honor, I didn't plan on that this morning. I came this morning prepared to put a prosecutor on so that Your Honor could hear testimony as to what that crime is in Michigan.
I haven't said that you can't do that.
I understand that, but I'm just...
Are you comfortable if we go the route where I tell the jury that that's not going to be an appellate issue that comes back, that I decided?
I would rather err on the side of caution and have the prosecutor testify to it. That's what I came prepared for. We only hit this because Mr. Kane says he doesn't want her to talk about that at all. I didn't come planning on doing anything different than what I've told you I came planning on doing. I brought a copy of the Michigan legislature statute so I could put it into evidence so that the prosecutor could then interpret it on the witness stand.
Mr. Kane, I mean, I don't see why that's not the proper way to go, and let the jury then decide whether or not it is a crime involving...
Well, if you're saying that it's a jury question of whether or not it's a crime involving the threat of violence or use of violence to another person, then we have no dispute. We want it to be a jury question. That's all. According to, I mean, based on the fact that it's an out-of-state conviction. As I said,
So that's going to change the standard instruction, so then I will never be making the determination and reading to them that it is.
I mean, I would object to changing the standard instruction. I think the standard instruction requires the court to tell the jurors as a matter of law whether or not a crime is or is not a forcible felony. If, for example, I had a crime that is not a threat, so I'm trying to think of one. I'm having a hard time thinking of one.
But let me ask you, what's the point of putting it on if in the end the jury instruction is going to say that it is? If that's what you're entitled to, that it is, then what's the point of putting on the prosecutor?
Well, because I still have to convince the court, I think.
But you've given me, I gave it back to you, I guess,
Yeah,
the
you
certified copy of the conviction, and you've argued that that's enough to convince the court.
And that's fine if the defense is not then going to argue the question of whether or not it's a crime involving violence is still up for debate. They can argue whether or not he was convicted, right? They can argue whether or not he's convicted, but not whether or not the crime itself is a violent crime. So the defense, as I understand it, wants to argue both, has the state proven he's even convicted, and was what he's convicted of a violent crime? I don't think they get to make both of those arguments per the way the instructions are written.
we are not arguing that the conviction has not been proven.
Okay. But are you arguing whether it's a violent crime?
We're arguing that it's a jury question. That's our argument. It is a jury question whether or not it is a violent crime. And as we all know, the instructions are not mandatory. The Supreme Court tells us that they are merely guidelines, recommendations, this court can fashion an instruction, we can all fashion an instruction that does not divest the jury of its decision-making power on whether or not the state has proven an aggravating element. We are not agreeing that it is per se proved by virtue of putting on an out-of-state prosecutor to testify to out-of-state law, somebody who is not licensed in the state of Florida, somebody who participated in the prosecution against Matthew Terry, somebody who is not qualified to come down here and make a comparative elements test, or even the state attorney. The state attorney's opinion is that the comparative elements test meets the prior violent felony. That's the state attorney's opinion, and the state attorney is asking this court to instruct the jury that the state attorney's opinion is the correct one, and they no longer have to consider that issue and whether or not an aggravating factor has been proven beyond a reasonable doubt.
Well,
We will more than happily.
there's still a credibility determination of the witness's testimony.
How?
You can cross-examine.
Well, I'm talking about Michelle Rogers, or are you talking about Ms. Gallagher?
I'm talking about Gallagher. You can cross-examine her on what the Michigan law is.
But
you can argue to the
even
jury
still,
that
that's not the point. The point is not her credibility. The point is what the court is going to accept as proven, and then telling the jury what is proven. That's the question. It has nothing to do with my cross-examination of Gallagher. I may not even ask her any questions.
Okay.
My point is it should remain a jury question whether or not this is a prior violent felony.
well, this is what I'm going to do. I'm going to allow the testimony, and then I'll make that determination at the appropriate time as to what the jury instruction should be.
Mr. Arm, so by that respect, I need a ruling as to whether or not the actual copy that I have of the Michigan statute is admissible or at least usable as a demonstrative, because the defense doesn't want the jury to see it at all. I would like to admit it, but if Your Honor is not comfortable with me admitting it, I would at least like to be able to put it up on the overhead and let the jury read it while she's talking.
Let me hear your argument, Mr. Kane, but I'm inclined to allow it as a demonstrative aid.
My argument is that it's not relevant.
All right.
What,
Well,
I mean, even still, when it comes to elements, the elements of the offense are not relevant in Michigan. Who cares what the elements of the offense are in Michigan? The issue is whether or not the conviction is a felony, violent felony. No, actually, it's whether or not it's a felony in Michigan, whether or not the comparable elements, in other words, the jury decides whether or not those elements meet whatever Florida law requires for a prior violent felony. Not in Michigan. Michigan law is not determining whether or not this is a prior violent felony. Florida law determines that. So what some out-of-state lawyer has to say about some out-of-state law is entirely irrelevant. What was proven at that, and that's where Michelle Rogers' credibility comes in. What was done to Michelle Rogers? That's the issue. Does what happened to Michelle Rogers meet the felony elements here in Florida?
Judge, I would just ask Your Honor, you don't have to answer it loud, but I would just ask Your Honor, what crime would Your Honor in your head think was committed against Michelle Rogers? The state would assert that it's aggravated battery, right? She's clearly touched against her will, and great bodily harm is done to her, and or a deadly weapon was used, but a deadly weapon is not a listed element of the Michigan offense. Okay? So I submit to the court that it's aggravated battery. Now, they're going to get a certified copy that's going to say assault. And in the state of Florida, assault and battery do not mean the same thing.
I agree.
How is the jury going to know that? How is the jury going to understand that in Michigan, what we call battery, they call assault?
I hear you.
And do I understand what kind of problems this opens up here? Because in Michigan, there is no comparable self-defense law. In other words, they don't have stand your ground in Michigan. Had this crime taken place in Florida, Mr. Terry very well might have raised a stand your ground motion, and it would have been granted immunity.
Your Honor, that's
Okay.
disingenuous. Mr. Terry argued self-defense in Michigan. His testimony in Michigan was he was attacked by Michelle Rogers. Michelle Rogers had the knife. He is the one who disarmed.
Well, but I'm not familiar with Michigan law, and I don't know what the elements of
I understand,
self-defense in
but
Michigan are.
But whether or not they have the word stand your ground is disingenuous to say he did not get a chance to raise a self-defense claim.
Stand your ground is not a jury question. Stand your ground is an immunity question of law for the court to decide.
I agree.
All right? We're not talking about what the jury decided in this case. We're talking about, if we're going to talk about elements, we're going to say this is what happens in Michigan. Okay? Mr. Terry was not granted the same degree of process in Michigan that he would have been granted here. Therefore, Michelle Rogers' credibility is an issue about whether or not this is a prior violent felony. We don't know what would have happened. So to bring in a Michigan prosecutor to talk about Michigan law in a very limited and narrow margin without talking about, okay, well, is there standard ground up there? Had that been raised? Obviously the jury, because he was originally charged with attempted first-degree murder, to some degree either rationally found fault with Michelle Rogers or in some way credited Mr. Terry's self-defense testimony with some amount of weight. He was not found guilty as charged. He was found guilty of a lesser included offense. Do we bring all that out? Right?
Well,
That's the point. Just look how messy it gets because the state essentially wants this court to instruct the jury that an element that they were required to prove beyond a reasonable doubt has already been proven.
Yeah, I hear you, and I started out this, and I haven't ultimately made the final decision. But what I'm going to do is I'm going to allow the state to call Gallagher. I'm going to allow the state to use the Michigan statute as a demonstrative aid, but not be admitted into evidence that goes back to the jury.
Yes, sir.
You said there were several issues. Are there other issues?
There are other issues, yes. We'll get to the next one now.
Yeah.
Your Honor.
Approximately how should I give the jury a break? Should I tell them to go get coffee?
I suspect, yes, Your Honor.
Seriously?
Your Honor, I apologize. I'm trying to clear these things with Mr. Kane so I can be prepared to do an opening and to proceed once you want to start calling witnesses.
All right. What's the next issue?
You want to look at these? In the meantime, Your Honor, I'm going to pass up what is a copy of the trial transcript of Kay Baker's testimony from the Michigan trial, so Your Honor can read over Mr. Kane's looking at the photos.
The state is proffering a number of photos from the home from the March 17, 2017 incident, and we're objecting to any and all of those photos as inappropriately elevating the 2017 case to feature status. We argue that any of those photos are first irrelevant, and if the court happens to find some degree of relevancy, then we would argue that under 403, the prejudicial effect greatly outweighs any probative value.
Substantially.
Wasn't Mr. Kane just 5 minutes ago arguing that the jury has to decide whether or not the crime is violent from the facts of the crime? So shouldn't I be able to show them the level of violence in the crime?
The violence is to the person, not to the kitchen.
Well, but the kitchen is where the incident happened. It's evidence. It's crime scene.
A bloody nose can appear to be a really terrible crime scene when in fact it's quite minor.
All right. So right now we're talking about the photographs.
We can talk about that or the transcript, whichever one Your Honor prefers.
All right. Well, I've heard the objection regarding the photographs as to relevance, and if I find relevance, which I do, as to violence, 403, I don't find that it substantially outweighs any probative value. So I'll allow the photographs.
Thank you.
What about the transcript? What's the issue with the transcript?
Your Honor, my understanding is defense's objection to the transcript. I wish to admit the transcript as it goes to, I believe, heinous, atrocious, and cruel.
Isn't she going to testify?
Miss Baker? She's dead.
No, this transcript is of who?
That's Kay Baker. That's Kay Baker's testimony in Matthew Terry's trial in Michigan.
I didn't. This is a surprise to me that Ms. Baker testified in Michigan. I was not aware of that.
I understand, Your Honor.
So let me take a moment to look at it. Ms. Baker, the victim in this case, testified in the case in Michigan.
On behalf of the defendant, and at the last sentence that you'll see that's not blacked out, She said the defendant's completely trustworthy.
Okay, this is a total surprise to me. I had no idea, and I guess I should have paid more attention to the names. But so this is the testimony of Kay Baker from this case before the court, testifying in the case with Miss
Rogers
in Michigan. All
Yes,
right.
sir.
All right, now I'm on the same page. And what's the intent of this? You want to introduce this.
I believe this goes to heinous, atrocious, and cruel.
How so?
Heinous, atrocious, and cruel is defined as shockingly evil, outrageously wicked. I think it's important for the jury to know that the person that Matthew Terry killed is not just his girlfriend. She's the person who went to trial for him before and defended him. It also goes, I think, to establishing that she was fully aware of exactly what he was on trial for before, which I think also goes to the apprehension of what she knows is coming. The state's position is that Kay Baker is uniquely situated. She doesn't just know that a man is chasing her with a knife. She knows a man who has
She testified for him in Michigan.
Right. She knows that she's being chased by a man who has already chased another woman with a knife. And
She
nearly
went
killed.
and testified that he was very truthful, and she trusts him completely.
Yes. And I think that that goes to the outrageousness and the shock that is inherently defined under heinous, atrocious, and cruel. Shockingly evil and outrageously wicked.
How do you intend to introduce the transcript?
I'll put it in through Ms. Gallagher, who will say that she was the prosecutor there at the time, that Ms. Baker took the stand, that she gave testimony, and then I would admit that. I did not print the page with the certification from the court reporter, but I can print that as well if you want to show that it is in fact a trial transcript. But I have previously provided it to the defense. I believe they know it's a trial transcript.
What are the objections from the defense?
First, I think the court used the word shocked. I don't even know where to begin. Is the court seriously considering letting this in? We can have argument, but if the court recognizes the absurdity of such a thing as well as the defense does, then you don't need to hear from me further.
I need to hear from you.
Okay. What the state is suggesting is that in order to establish EHAC, it wants to introduce statements made by the victim regarding the accused more than 5 years before the event. What's the relevance of that?
I trust that, though.
I don't know the exact date, but I think it's October 2018.
I trust that. More than 5 years. Okay.
No, or actually, it would have been October, yes, more than 5 years,
It'd be 4, but
2017.
All right. We don't need to split
Well,
that.
whatever, it's fine. Yeah, you're right, you're right,
2017,
you're right.
all right. Let's all be on the same page when it comes to math. October of 2017 was more than 5 years ago. All right. You can take judicial notice of that. So what is the relevance of Ms. Baker referring to Mr. Terry as trustworthy and 5 years before the event? I mean, I don't understand, okay? So that is the nature of our objection. What is the point? What is the connection between, because EHAC has to do with suffering. All right, we don't know what was going on inside Ms. Baker's head. We don't know what she was thinking. We do know that she was heavily intoxicated, more than twice the legal limit. Okay, we know
But the
that.
state has to make argument to prove that, and they're trying to get in evidence or facts that they can then, whether the jury buys it or not, but they want to get these facts in, what she said, she trusts him, and then make argument to the jury that satisfies.
Well, why is that not inferred from the fact that they lived together? Why is that not inferred from the fact that he had just moved down and lived in her home, where her sons were, for 4 or 5 months? I don't understand. I mean, what is the connection between somebody saying something nice about somebody and 5 years later they're being a victim of hostilities targeting them? What is the relevance other than to inflame the passions, rather than to say, oh my goodness, look what she did for him. She testified for him in a sentencing proceeding in Michigan, and now he's doing the same thing to her. All right, so the jury, the state wants the jury to know that Miss Baker was aware of what happened to Miss Rogers, and somehow make the connection between that and EHAC. If the state has any case law that says that EHAC can be proven by 5-year-old compliments in a court proceeding,
Well,
then
it's not
I
gonna
would be very curious to see that. Well, what is the relevance? What is the relevance? How far out are we going to take EHAC? Now we're going to take it to insult, right? He's insulting her. He's insulting her trust. He's insulting her faith. He's insulting all the wonderful things that she thinks about him. You can see her putting his arm around him in the bar an hour earlier. There's obviously trust there. She's
Well, and I
walking out
suspect
with him.
I was looking at the exhibit list. There's photographs. Those are photos of family and friends. Do you have photographs of the two of them together that you intend to introduce?
No. Your Honor, the question here is what the defendant did something that falls in the nature of vile, shockingly evil, outrageously wicked? Shockingly and
Well, let me
outrageous.
ask you, are you suggesting that it would not be if she had not testified or had not known about, would this not be EHAC if she had not known about his prior conviction?
No, but I think that as you keep adding things on, it gets easier and easier for a person to conclude that. Again, go back to the analogy I kind of borrowed. Where does shockingly start, right? Where does strikingly start? Does it start on the dial at 6? Does it start on the dial at 7? Does it start on the dial at 8? The point here is Matthew Terry, the defendant, knew that all of this happened. Matthew Terry would have been seated in the courtroom and was seated in the courtroom when Kay Baker got on the witness stand and said those words in his defense.
But what does that have to do with the night of the incident here?
Judge, this is a non-statutory aggravator. That's what the state's trying to bring in here. They're trying to bring in a non-statutory aggravator of domestic violence. Look how wonderful and loving she was towards him, and look ultimately how he insults that and offends that sensibility by committing such an awful act against her. He's trying to expand EHAC into a non-statutory realm.
Judge, that's not correct. I continue to quote to EHAC. What constitutes shockingly evil? What constitutes outrageously wicked? Like what goes into that? What transforms a normal murder that does not qualify for the death penalty into one that does qualify?
Judge, I'm sorry, I know this isn't my phase of the trial, but I just want to put some case law on the record. We're getting lost in weeds.
Why don't you wait till I rule? But let me read. I have a case in front of me that I want to read.
Okay.
Gonzalez versus State, Florida, 2014. Is that one of the ones you wanted to put on the record?
Just one of them, yes.
Okay, well, I've got that in front of me, so let me do my job here, and I'll let you do your job.
Beyond outrageously wicked and shockingly evil, I have also said that this goes to the victim's knowledge and therefore the apprehension that is also a part of EHAC. The victim has to be not only conscious, but she needs to be aware. She has to apprehend what is coming. That's what makes it torturous.
But what about the prior? And I apologize. I mean, you made some argument previously, but I mean, if a man is coming at her with a knife, how is that distinguishable from whether she testified for him in Michigan before? What makes it that significantly different of her knowing what's coming? She's been stabbed. I mean, the jury found him guilty of stabbing her multiple times. The testimony was, lots of testimony regarding how and how many wounds were inflicted. You're suggesting that the jury needs to know that she knew he did it before in order for her to have been conscious of what was happening to her?
I take issue with your word need. She does not need to know, but it does go to EHAC if she does know. That's the difference. It's not essential that there's no requirement that every victim of EHAC has previously testified in the trial for the defendant in some other similar crime.
Clearly.
It's not a need issue. It's a question about whether or not it goes to the elements of EHAC, whether or not it's shockingly evil, outrageously wicked, right? Which is the reaction Your Honor said, not even knowing where we were going. You said this is shocking. That's the words you said. But beyond that, separate apart from shockingly evil and outrageously wicked, there is the question of the knowledge, of the apprehension that goes to the torturous element.
Go ahead and put your case law on the record.
Thank you, Your Honor. The HAC aggravator focuses on the means and manner in which the death is inflicted and the immediate circumstances surrounding the death. That is well-settled black-letter law in Florida. That's pursuant to multiple cases, a few I'll put on the record. Lynch v. State, 841 7th 2nd, 362, Florida Supreme Court, 2003. Martin v. State, 151 7th 3rd, 1184. Florida Supreme Court, 2014. Jordan v. State, 176 7th 3rd, 920, Florida Supreme Court, 2015. It has been well settled for over 20 years. HAC only has to do with the immediate circumstances surrounding the death and the means and manner in which the death is inflicted. This transcript has absolutely nothing to do with that, has absolutely nothing to do with either EHAC or prior violent felony, and cannot be admitted.
All right. Mr. Dirks, you're standing there. Did you have something in your hand? Is there something specifically that you want to put on the record or make me aware of?
Yeah, I want to put on the record the cases that stand for the proposition that the victim's apprehension of her impending death is a critical issue for heinous, atrocious, and cruel.
Is there any doubt, though? Do you doubt in this case that she had any apprehension under the facts that's already been testified of this incident of her impending death?
The heightened awareness of her impending death. Remember, the court has already admitted Williams' rule. The court has found that the circumstances surrounding the killing of Michelle Rogers are so similar to this killing that this court permitted Williams' rule evidence. Our argument on closing argument is going to be this, Your Honor. The degree of tortuousness, the degree of knowledge of Kay Baker's knowledge of her impending death came together as she jumped out of that window. She now realizes, I can't trust him. I was wrong in my trust. She jumps out the window. She says, wait a minute. As she's running away from him, she's now realizing the same thing that's about to happen to her is the same thing that happened to Michelle Rogers. Imagine the terror. Imagine what was going through her mind in those last minutes before she was brutally murdered. That heightened awareness comes directly from her knowledge about what happened in Michigan, that she trusted Matthew Terry. Now all of a sudden she realizes in those last deadly minutes that now all of a sudden it's different. She was in sheer terror. She knew exactly what was going to happen to her. That heightened awareness is entirely relevant and admissible, and I cite Bright v. State, 299 Southern 3rd, 985, Cox v. State, 819 Southern 2nd, 705, 808 Southern 2nd, 110 is Francis versus State. All stand for the proposition that the victim's heightened awareness of her impending death are entirely relevant, and that is exactly what we intend to argue to this jury.
Let me ask you specifically, though, is it the fact that she said she trusted him, or is it her knowledge of the prior event?
It's both of those, Your Honor. It's the fact that she said, she in effect said, oh, that stuff that happened regarding Michelle Rogers, I don't believe any of that. That isn't really what happened. I'm trusting him. He didn't do that. Now all of a sudden, when the very same thing is happening to her on May 28th, 2022, it all comes together. It all comes together. Think about what was going through her mind after it all comes together, after she trusted him, and now she realized she couldn't, and she's now about ready to suffer the same fate.
Mr. Diaz?
Your Honor, if Your Honor takes issue with the transcript and the words in the transcript, I'm fine with foregoing the transcript, but I would ask for permission then to have Ailish Gallagher testify that Kay Baker went to Michigan. She served as a defense witness on the defendant's behalf in his trial. And if you don't want them to see that she says the words, I trust him completely, I don't think that that's the correct ruling, but of course I abide by Your Honor's ruling, and I would at least rather get something than nothing.
All right, any last word from the defense?
Wait just one second. Judge, I would just point out that the cases cited by the state have to do with things that the victim would have been perceiving as a result of what was being done to her. For instance, they cited Cox. The impending death awareness was because her lungs were filling up with blood at that moment during the death. It had nothing to do with anything that occurred 5 minutes, let alone 5 years prior to the killing. However, in regard to their last statement, if they simply just want to put in that Kay Baker had testified on his behalf, we don't have a problem with that, but nothing else.
Okay. All right. That was going to be my ruling anyway. I mean, I find that it's relevant because it's evidence that she endured fear of emotional anguish due to the knowledge of the prior incident, but we don't need to get into the details. If she testified at the any proceeding in Michigan, I think it's enough to give the state the opportunity to make that argument.
I just want to clarify. The testimony that's going to be allowed is she testified as a defense witness on behalf of the defendant.
Yes,
Yes.
But
Okay.
no details, that
Yes.
is all.
no problem.
Okay. All right. Next issue. So no transcript. Any other issues?
My piece of body cam footage is here. If Your Honor wants to deal with it now, we can deal with it now, or we can.
I'd like to get the jury in
I
and
was going to
do.
say, we could put Dr. Perkins on and then take a break.
Let's do that. Defense ready?
Yes.
All right. State. That means you're ready.
Yes, Your Honor.
All right. Let me get the jury. I'll apologize to them and take full responsibility.
Can I tell you right now?
All right. Just go slowly. Mr. Kane is running to the restroom, so we won't bring him in until he's back. But if you want to line him up. Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome. First of all, I apologize for the late start. I know that you all have been sitting back there. I appreciate your patience with us, or me, because you know that I'm going to take full responsibility, and it is my responsibility, so please don't be mad at anyone else, the parties, the attorneys, or anyone else for the late start. But as I indicated to you yesterday, we were going to proceed now to phase 2 of this trial, which is the penalty phase. The first thing that I want to do is ask you, as I always do, was anyone exposed to anything about this case outside of the courtroom between the time you left yesterday and the time you've returned now, by show of hands? Did anyone discuss, let the record reflect there are no hands, did anyone discuss, either amongst yourselves or with anyone else, anything about this case between the time you left yesterday and the time you returned into the courtroom this morning? Let the record reflect there are no hands. Again, thank you all for your complying with those requirements. It is very, very important. I do have a preliminary instruction that I am going to read to you. It is only 2 pages long before we begin the penalty phase. And then, similar to the first phase, the attorneys will have an opportunity to present opening statements to you regarding this phase. Members of the jury, you have found the defendant guilty of 1 count of murder in the 1st degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proven beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, 3, whether mitigating circumstances are proven by the greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if, having a conviction, it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. That is all of the instruction. I am now going to turn to the state and ask if they wish to give an opening statement. Mr. Diaz, you may proceed.
Thank you. You have already found Matthew Terry guilty of first-degree murder. The only question now is what is the sentence he should receive. As part of today's proceedings and the days that follow, the state of Florida will show you that there are two aggravators that exist in this case. The first is that the defendant has previously been convicted of a felony involving the use or threat of violence to another person, and as you might guess, that case is the case involving Michelle Rogers. The defendant was ultimately convicted of the crime where Michelle Rogers was the victim. We will put into evidence what is commonly known as a certified copy of conviction. It's a certified record from the clerk's office in Michigan, Lansing, where the case took place, and it will show you that the defendant was ultimately found guilty of a crime that in Michigan is known as assault with intent to do great bodily harm less than murder. But beyond putting on a piece of paper in front of you, a certified copy from a clerk that tells you that the defendant was convicted of that crime, the state of Florida will put on Assistant Prosecuting Attorney Ailish Gallagher, who works from Ingham County. That's the county that covers Lansing, Michigan. And she will come into court today, and she will tell you that she was the prosecutor on the case. She was there the day the verdict was read. She was there when the defendant was found guilty of the crime that I've listed. And she will talk with you about what that crime is in the state of Michigan, so you can ultimately determine whether or not it comports with the notion of a crime that involves the use or threat of violence to another person. But beyond that, you will be able to obviously consider the testimony that you've already heard from Michelle Rogers. Remember, the things that are already in evidence from guilt phase are still part of the evidence that you can and should consider. But beyond the photos that you've already seen, beyond the testimony that you've already heard, we will also be recalling Detective Crumbach, and he will come in and he will talk with you about the rest of the crime scene. So you can see the real brutality of this attack. You'll see the spot in the kitchen where the blood is. You'll see the bloody handprint on the wall next to the garage door opener. And you'll see the spots of blood progressively moving down the driveway where Michelle Rogers was attacked. That's the first aggravator, that the defendant was previously convicted of a violent crime. The second aggravator is one that's known as especially heinous, atrocious, or cruel. And the court, I anticipate at the end of the trial, will define those words for you, though you'll have to decide how helpful the definitions are. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. And you don't have to take these down because, again, at the end, the judge is going to give you the instructions. You'll have them in black and white. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. And then finally it will tell you the kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional facts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to the victim, who in this case is Kay Baker. And so one of the other witnesses you'll hear this morning is you'll hear from Dr. Perkins, who you may remember was the autopsy doctor. She will come and talk to you about the autopsy, but what she will really come and talk to you about is she will talk to you about the level of pain and suffering that the victim, Kay Baker, would have gone through in this case. How painful each of those stab wounds would have been. How long it would have taken her to bleed to death. How she would have been conscious and aware and knowing that death is coming, feeling life slip out of her. That is one of the things you will be able to consider, is the fact that the victim in this case knew that death was coming. That is the torture element the state will ultimately submit to you, that she knows her death is coming. That's what makes it torturous. But beyond that, you will, of course, be able to consider all of the facts that you've already heard, all of the evidence that you've already seen, the nature of the injuries, the extent of the injuries. For example, you also can consider the way in which the crime unfolded, that at some point Kay Baker was on the ground, helpless and defenseless, with someone over her, attacking her, opening her throat. But what you'll also hear is that Kay Baker was a witness in the first case against Michelle Rogers. She went all the way back to Michigan, and there she served as a defense witness on behalf of the defendant before he was ultimately found guilty. And the state will ask you to consider how that fact played into the mind of Kay Baker. How the fact that she knew what the defendant had previously been accused of and ultimately found guilty of played in those final moments of her life as she's running, fleeing, fighting, and ultimately dying.
Objection, reapproach, please.
as well as all the other things that you may take into consideration, it's the state's position that when it comes to the first of the 5 questions that the judge has already sort of read to you, but I will repeat, you will unanimously find that the state has proven beyond a reasonable doubt the existence of each of those aggravating factors. Obviously, there's a certified copy of conviction that will make determining the previous conviction very easy to determine. But beyond that, you will find that the prosecution has proven beyond a reasonable doubt the aggravating factor of especially heinous, atrocious, and cruel. And given the nature of those aggravators, you will be asked to decide whether or not they are sufficient to merit consideration of the death penalty. And I again assert to you that having looked at all the information, you will reach the conclusion that it is sufficient. Now, you heard His Honor talk about mitigating factors, and he talked about how you don't even have to be unanimous as to whether or not mitigating factors, that's sort of an individual decision. I'm sure that some of you, at least one of you, will find that there's a mitigating factor worth considering. And so that will push you on to the next consideration, which is whether or not the aggravators outweigh the mitigators. And I submit to you that having heard all of the testimony, having seen all of the evidence at the end of the trial, you will move on past that question because you will find the aggravators do outweigh the mitigators, and you will answer the ultimate question. And so at the end of this trial, I will stand up here and I will ask you to find the defendant is worthy, is deserving, and should be sentenced to the death penalty because the murder that he committed here was a second time that he's committed a violent crime against someone, particularly an exceedingly similar one based on the facts that you've heard, but also that what he did to Kay Baker on the night or the early morning of May 28th, 2022 was especially heinous, atrocious, and cruel. Thank you.
Thank you, Judge. Please support. Ladies and gentlemen of the jury, counsel. Good morning. Good morning. It's been a while since we had a chance to talk, and I believe we'll have a chance to talk one more time before you all are given this part of the case. Now, we always first acknowledge that there has been a tragic loss and that many good people are suffering, whether it's the Baker family and friends, Matthew Terry's family, his friends. And as you've probably gathered at this point, Mr. Terry and Miss Baker knew each other for quite some time. They had known each other for about 20 years when this happened. They all spent a lot of their adult lives up in Michigan. Miss Baker had only come down to Florida maybe about 10 and a half years ago, and she was a school teacher here. And Matt came down only recently, back in January or February. So Matt had only been down for about 4 months, and he lived there with Kay. And as I said, these weren't strangers. These aren't people who met each other, online. It's not the kind of relationship that Matt had with Michelle Rogers. They met online and they developed a romantic relationship. When it came to Kay Baker, it was quite different. The Terry family knows the Bakers. They're all, many of the people involved with this case are very close to each other. There's some history. It's not random. Matt and Kay had known each other for about 20 years, and Kay met Matt through Matt's brother, Peter. So, that makes it that much more tragic. That much more suffering, a sense of loss. And we appreciate that and we respect that. And there's nothing that we're going to say or do that is in any way intended to minimize that loss, to detract from it. We're never going to ask you to take your eyes off of those who are suffering and continue to suffer in this case. Because your decision is, in many ways, what's going to happen to Matthew Terry exists by operation of your verdict. when you decided collectively that Matthew Terry has been convicted of first-degree murder, you decided, and as we talked about in voir dire, you decided that he was going to die in prison. That is a decision that you all made collectively and unanimously, and we're not going to ask you to change your minds about that. When we call witnesses or when the state calls witnesses, that is in no way intended to disrupt or disturb your verdict. Your verdict is a fact. And facts don't change. And we're asking you to really to pay attention to some more information, to take more information with you in deciding something else. Now, that decision does not necessarily have to be collective. If you're going to decide that Matthew Terry is going to be executed, that has to be a collective decision. You will decide first whether or not something has been proven beyond a reasonable doubt, the aggravating factor. And then you will decide whether or not that one or two aggravating factors are sufficient to impose the death penalty. In other words, those facts that you now have, if you believe they have been proven, you're first going to ask yourself, is that enough to impose the death penalty? And if that's going to happen, that has to be unanimous. That's another part of the collective agreement that is required in order for something beyond life to happen. So in many ways, and as we talked about, you have already sentenced Matthew Terry to life in prison. You've already done it. Right? Where he dies is not an issue here. It's how he's going to die. Is he going to die naturally, or is he going to die at the hands of human beings? Lethal injection, electrical chair. So in order for that to happen, you all have to be in agreement. Now, what's different about a life sentence is that agreement is not necessary. We talked about that as well, didn't we? That one of you, because each one of you is a judge imposing a sentence, one of you can decide at any point that life is the appropriate sentence. And we're going to be giving you some testimony from various witnesses on why we're asking you to do that. So who are those people? Who are we going to be asking you to take with you into the jury room? Whose testimony? Mark Terry, Matthew's father. Kathy Terry, Matthew's mother. Friends of the family who have known Matt since he was a really, really young boy. Ben and Ruby Williams. Steve and Debbie Glassner. These names may sound familiar. You heard them during voir dire a little bit. We're going to also bring in a prison expert, Mr. Aubrey Land. Now, Aubrey Land is going to give us some insight into something that many of us know nothing about, and that is, what is it like to be on death row? What is it like to be serving a life sentence? Those are very different things in the Department of Corrections. And he'll walk you through exactly what a day in the life of a life in prison inmate looks like, and what a day in the life of a death row inmate looks like, and how drastically different they are, and how the requirements of inmates are quite different. You're going to hear that when you're serving a life sentence, you have to earn your keep. You're going to, there are many interesting things about the Department of Corrections, and that is more than 90% of the labor comes from inmates. In comparison to death row, where they're not allowed to work. And remember when Mr. Diaz was talking about DNA, and he was talking about how 99% of our DNA is the same? And it's that 1% that sort of distinguishes us from everybody else. And what that really means is that every person in here, every person listening to these proceedings is a human being. And that we are all so alike. And what makes us different, what really genuinely makes us different, and what makes Matthew Terry different from the rest of us? What is unique about him? What is worthy? And we are going to hear some things about Kay Baker that make her unique. And all we're asking is that, yes, when you hear about what a wonderful and beautiful person she was, it's very disturbing that her life was taken away and that she endured something horrible. That is very disturbing and very hard to fathom and understand. And you have decided collectively that Matthew Terry was the one who did that, but does that mean that he no longer has value? Does a conviction for first-degree murder, even under horrific circumstances, mean that somebody forfeits their value? And some of us may immediately say to yourself, yes. That may be your first reaction, that he forfeits his life. He no longer has value. We don't care how talented he is. We don't care what a good person he was in the minds of those who love him and perhaps still is. But that may be your first impression. And remember, we talked about that life and death, regardless of what your sentence is, it comes from a principled viewpoint. It comes from a place in you that says, this is moral, and this is right, this is just. And we can't question those things, and we never would. But the reason you're sitting here is because you had said, even if I believe that the death penalty is appropriate in some circumstances, even if I believe that a life sentence is appropriate in certain circumstances, what does that mean you're saying? It means you're saying that you will make your decision based on, first, what you hear, and then secondly, how you feel. Because all those feelings you have, that's a part of the 99%. Our capacity to feel something. And some of you, remember from voir dire, said that your reason for a life sentence may just be a feeling. And how precious that is. So, who is Matt? Who is he? What's interesting is that and you've heard, I don't know, we're in our third week now, the third week of our journey. How many times have you heard the state refer to that man? How many times have you heard Mr. Diaz refer to the defendant? That man. How many times have you heard Mr. Diaz refer to him as Mr. Terry? You don't hear Mr. Diaz referring to Kay Baker as the victim. He always refers to her by name, but he never refers to Mr. Terry by name. Why? What is the purpose in reducing somebody to a category? Is it that hard? Is it that difficult to say Mr. Matthew Terry? Is it that difficult to refer to him by name? Unless there's... So as we proceed, I would ask you to pay attention to how the state refers to Mr. Terry. Throughout this process, when he's questioning witnesses or in his closing argument to you. Now, he may change at this point, but if he continues to do that, I would ask you, what is the purpose? You can factor that into your decision making. Because, as you know, when we reduce people to categories, we dehumanize them. And if the state successfully, in this process, dehumanizes Mr. Terry, how much easier is it for you to execute? Because if you're executing somebody who shares that 99%, then it's a little bit more difficult. So throughout this entire process, he has a name. He's a person. That's who we're talking about here. Somebody who was born January 8th, 1975. Born and raised, for the most part, in East Lansing, Michigan. Just like Kay Baker. Spent some time in the western part of Michigan. Grew up fishing. Comes from a good family. Has a degree in computer engineering. He's a United States Marine. Served honorably from 1993 to 1997. Had a daughter. Her name was Jessica. 2 months after Mr. Terry was sentenced to prison for the assault on Michelle Rogers, he was convicted of that. We're not going to dispute that. And as a result of that conviction, in December of 2017, he was sentenced to 3 years to 10 years in the Department of Corrections up in Michigan. Two months after he was given that sentence, his daughter Jessica overdosed. She was 19 years old. His parents, Mark and Kathy, had been married for a little more than 50 years. Jessica came from a tragic background. Her mother raised her for the most part, and Matthew raised her for the most part in different parts of the state, or different parts of the country. And she had a very troubled upbringing. And Matt rescued her from that and tried to help her as much as he could. These are things you will hear about, and they're very disturbing, very painful, but they're very real. Very real. Matt got his undergraduate degree in computer engineering. He's a very gifted man when it comes to computers. And Mr. Land, Aubrey Land, is going to talk to you about the value of that and how that would be a tremendous asset to the Department of Corrections if Matt were given a life sentence. You'll hear about his prison record from Michigan and how he mentored and tutored young inmates, helped them get their GEDs. You'll see that in the prison records. And you'll also hear from a few deputies who will talk about that in the past 6 months or so, since Matt's been incarcerated at Falkenberg Road Jail, he's had no disciplinary infractions, and he's actually been elevated to trustee status. And what's the point in all that? What are we trying to say? That prison removes any danger you may perceive him to be. Prison removes any danger. If there's ever any fear that he will be in another relationship with a woman, scratch it. It's not going to happen. He will never be in another relationship with a woman again, ever. And if that is any comfort to you, if that is any sort of mitigation, then that is a reason for life. That is value. There is value in that. There is value in his education. There is value in his ability to conform to the rules. Just like he served honorably in the Marine Corps, he had no issues in the Corps, he had no issues in Michigan DOC, and he's had no issues here in Falkenberg Road Jail. None. You will hear evidence of that. And if that is something that you value, as well as the love that his parents have for him, if that is a reason for life, anything that I have said that you believe is proven, if you see that as in any way persuasive, convincing, and I'm going to say one thing further, and then I'm going to sit down. Even if nothing I say is convincing to you, all it takes for you, any one of you, to have a belief, a conviction that life is superior to death, that is enough. You don't have to believe anything that I say. You don't have to believe anything that comes out of a witness's mouth. If you believe that life is sufficient, then that's it. It's done. If you don't believe that the aggravation is sufficient, it's done. It's over. If you believe that mitigation outweighs the aggravation, it's over. If you don't want to talk about it, just like if you don't want to talk about your reasons for your faith, your reasons for living where you live, your reasons for loving the person you love, your reasons for any of it, you can knock on the door and it's done. That is the individual moral assessment that each one of you as a judge possesses, and it's never taken away from you. We welcome and we encourage deliberation, but it is not required. The only requirement in any of this is that the state prove to you an aggravating factor, and the state prove to you unanimously that death is the only appropriate choice here. Life requires no proof. Remember that, please. A life sentence requires zero proof. And compare that to what has to be proven for a death sentence. And what is Florida saying by that? This state, by virtue of that burden, practically admits to you that a life sentence is superior to a death sentence. And thank you all again for your wonderful and kind attention, and I look forward to speaking to you again. Thank you.
Thank you, Mr. Kane. I'll ask the state to please call your first witness.
Yes, Your Honor, the state would recall Dr. Ashley Perkins to the stand.
Dr. Perkins. I intend to re-swear all the witnesses since there's been a break, if anyone who's testified previously.
Thank you, Your Honor.
Dr. Perkins, good morning and welcome back. I'm going to swear you in again before you take the stand. If you'll raise your right hand, please. Thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, Doctor. If you'll follow the bailiff to the ramp. Witness chair is in the same place as you were last time. Go ahead, have a seat, make yourself comfortable. Deputy State, can you make sure that microphone is on? It's on now, and it is adjustable. You let me know when you're ready if you've got stuff you need to unpack.
Okay, ready.
You may proceed.
Thank you, Your Honor. Good morning, Dr. Perkins. I know you've already introduced yourself to the jury. You've testified, I guess it was last week, where I asked you questions relating to the cause of death and as it relates to the guilt phase. As you know, we're now in the penalty phase, and so the issues have changed. The issues that I want you to talk about with the jury don't have anything to do necessarily with the cause of death, but more with the findings that you made, your autopsy.
Object, Your Honor.
Legal basis?
We have no question. Because this is
Yeah, let's form a question. Like, you don't have to the background. Just form a question. Let's get to the point.
Yes, Your Honor. Dr. Perkins, I want to talk with you about your findings as it relates to any suffering, any experience that Kay Baker had during the course of the events.
objection, Your Honor. Your question, please.
Well, turn that into a question.
Yes, Your Honor. Dr. Perkins, you talked about the injuries to Kay Baker, and I want you to presume that Kay Baker was healthy, alert.
Objection, Your Honor. Is there a question, please?
No, I'll allow this.
I want you to presume that she's healthy, she's alert. She's alert enough that at about 11:46 p.m. on the evening of December 27th, she texted, or at least her phone displayed a text where she says, "All is good."
Objection, Your Honor.
Legal basis?
Relevance?
Overruled. I'll allow it.
Assume that she's healthy, assuming that she's able to ambulate, assume that she was able to drive a motor vehicle home between 11:30 and 11:46. Assume that she's healthy, and she states all is good, and then I want you to further assume the individual at 12:29, a 911 call is made,
Objection,
and
Your
she
Honor.
looks like this.
Legal basis?
Can we approach, please, and
Certainly.
take a picture while we're at the bench?
Yes.
All right, Dr. Perkins, I stand corrected. The text came in 11:56, not 11:46. Assuming that, assuming then you were at the scene, weren't you?
Yes.
And you saw the appearance of Kay Baker when she was still at the place that she was found at 6209, beside the patio at 6209, or the front door at 6209, weren't you?
Yes.
Okay. Assuming that those facts, along with your autopsy report, I want to talk with you about Kay Baker's ability, sensory capabilities during that time between the time that she was alive, 11:56, and the time when she actually died. You talked about all the injuries that were inflicted upon her.
Objection, can we have a question, please?
Finish the question.
You talked to us about the injuries, and you mentioned that your wound, Roman numeral 2, you recall in your autopsy report, Roman numeral 2, the large gaping wound on the neck that starts at about 2 o'clock and goes around at about 8:30.
Yes.
Was that likely the last wound that was inflicted upon Kay Baker?
Yes.
You talked extensively about numerous other wounds, either stab wounds or incised wounds, that were inflicted upon Kay Baker by Matthew Terry on that evening. My count is that it was somewhere between 20 and
Objection,
20.
can we have a question, please?
Don't testify. Just ask the question.
How many separate wounds were inflicted upon Kay Baker by the defendant?
So it ranges because some of the wounds commingled, so it was impossible to tell an exact number, but somewhere in between 20 to 25 would be a good range of injuries.
Okay. And getting back to Roman numeral 2 that you had, let me show you a photograph if I may. About the various injuries that you noted in your autopsy of Kay Baker. We talked about Roman numeral 2, the large gaping wound, and you described the various structures of the neck which were damaged in addition to the other structures. Let me ask you the ultimate question. Based upon your autopsy and all the injuries that you saw in the neck of Kay Baker, what structures were left of the neck of Kay Baker which allowed her neck, which allowed her head to be attached to the rest of her body?
So she still had the muscles on the right side of the neck on the anterior portion, the front portion of the neck. There was a carotid artery, major vein, two major veins on that side that were still intact. And then her spinal column, which is the bony portion, and then the spinal cord, which is protected by the bony portion that communicates information from the brain to the rest of the body.
All right. And those damages, injuries that you saw to Kay Baker, could they have been inflicted with a 3-inch bird's beak paring knife?
That's possible.
Now, you mentioned that a major structure that was left was the spinal column and the spinal cord. Are parts of those structures bony structures?
Yes, the spinal column is the bony portion.
And would it be more difficult to use a bird's beak knife to sever the spinal cord or the spinal column? A lot of force would have to be used with a small knife like that in order to go through the bone. All right. So as you mentioned, the spinal cord, the spinal column is the structures that allows communication between the head and the rest of the body.
Correct.
Does the fact that Kay Baker's spinal cord was left, did that have the effect of permitting Kay Baker to be conscious and experience the pain of the attack by Matthew Terry?
Yes. So the brain and the spinal cord were all intact, so that would allow for the sensation of feeling.
All right. How many different damages, how many different injuries, how many different wounds did you see to Kay Baker?
Again, it's impossible to tell exactly, but with just the sharp force injuries, so that's the stabbing and then size wounds, that includes somewhere in the range of 20 to 25. And then there were a few small blunt impact wounds, so those are the bruises and abrasions that I saw that were small and scattered, somewhere in the range of 10.
Okay. Okay, with those 20 to 25 incised wound, the other 10 regarding all those injuries, was Kay Baker alive and conscious for every single one of those?
Yes, there were hemorrhagic reactions with the incised wounds, the sharp force wounds, so she had a heartbeat at the time that she received those injuries, and then in order for the body to react to the blunt force injuries, so to create those contusions and the reddish abrasions, she had to have a heartbeat for those as well.
Was she able to see?
There was no impairment to the visual tract, so she would be able to see.
Okay, and based upon your findings as a forensic pathologist, from that standpoint, was there any impairment on Kay Baker's ability to perceive events around her?
There was nothing that would imply that she had decreased appreciation to perceive.
Was there any impairment from your findings of her ability to perceive a danger, someone chasing her? Hold on.
I'll allow it.
There was no injury to the brain that would impair her to be able to perceive that danger.
And you said the spinal cord was not damaged, so could her brain send signals to her muscles, for example, to try to defend herself from someone who is attacking her?
Yes, sir.
that large gaping wound that you talked about, was that likely the last wound?
It's likely the last one.
You were at the scene, weren't you?
Yes.
You were at the scene. You saw the collection of blood. You saw her location. Did it appear that the injury, that large gaping wound, and I'll show you if I may, Station Exhibit number 59C, if you would take a look at. And did it appear that that was the last wound that Kay Baker experienced?
Yes.
So the other 20 to 25 incised wounds, they all were done before that last gaping wound. Was she able to experience the pain as those wounds were inflicted?
Yes.
I know you can't determine the order of those injuries. Is that correct?
Correct.
You talked about some. Do you know what defensive wounds are?
Yes.
And did you see items or injuries on Kay Baker's right hand and left hand which were consistent with defensive wounds?
Yes.
And assuming those are defensive wounds, were those wounds that were inflicted when Kay Baker was alive and conscious and able to perceive pain?
Yes.
Were those wounds that were inflicted when Kay Baker was able to perceive a danger or an attack, and those defensive wounds were inflicted when Kay Baker was trying to fight for her life?
Yes.
Actually, I'm going to show you what has been marked as State's Exhibit number 59V.
No objection.
I'm sorry?
No objection.
All right. Same. Let me see. Same. Is that the one we talked about up here? Yeah.
It was.
Same move.
All right, 59V. Do you recognize that one?
Yes.
Okay. And where was that wound?
It's on the back of her neck on the right side.
Was this wound fatal or potentially fatal?
Potentially fatal without medical intervention, as it hit a lot of musculature, but no major vessels.
All right, so this is on what appears to be the back right side of her neck.
Correct.
Basically on the opposite side of her neck from the large gaping wound that we talked about before.
Yes, sir.
That wound in 59V was Kay Baker alive and able to experience the pain associated with that wound?
Yes.
We talked about defensive wounds. I'm going to show you what has been marked for identification or admitted as State's Exhibit number 60B. Admitted as 60B. Do you recognize that as is that the left hand of Kay Baker?
Yes, sir.
Those are examples of the defensive wounds that you testified about last week and you testified earlier today.
Yes. Yes.
Those are one of the 12, some of the 12 separate defensive wounds on the left and right hand of Kay Baker. Is that right?
Yes.
Was Kay Baker alive and perceiving pain, experiencing the pain for each one of those 12 defensive wounds?
Yes.
based upon your autopsy findings, was there anything that prevented Kay Baker from experiencing the pain from every single one of those wounds that you've talked about prior to that last wound that was inflicted on Kay Baker, your Roman numeral 2?
No.
In fact, was Kay Baker alive and conscious and able to experience pain at the moment that that wound was inflicted?
Yes.
And how long was it before she was unable to either breathe or not experience the pain any longer after that last wound was inflicted?
I can't give an exact time, but major artery, major veins were transected along with the larynx, which would be her airway. So it'll take some degree of seconds, likely more than 3, and not more than a few minutes, probably less than 5.
Upon the infliction of that injury, that large gaping wound, would she be momentarily be physically allowed or capable of at least expressing some sort of audible noise?
Her larynx, which is the major airway right above the vocal cords, was transected, so that would limit much in the way of actual noise that she'd be able to make.
So as soon as that larynx is damaged the way that you described, she could no longer voice.
She would no longer be able to voice, correct.
If Matthew Terry's objective was to inflict severe pain and torture on Kay Baker, from a forensic pathology standpoint, did Matthew Terry attack Kay Baker?
Objection.
Well, let him finish the question.
Let me repeat the question if I may start over.
Okay.
If Matthew Terry's objective was to inflict severe pain and torture to Kay Baker, did Matthew Terry attack Kay Baker in a place and in a manner which accomplished this objective?
Objection.
Hold on. Rephrase the question.
Did the manner in which Kay Baker was attacked by the defendant inflict severe pain and torture to Kay Baker?
Objection.
Rephrase the question.
If Matthew Terry inflicted the wounds that you saw in your autopsy findings, those 20 to 25 wounds,
Objection.
Well, he hasn't finished the question. And then I need a legal basis.
Right.
If there's an objection.
were those injuries inflicted causing severe pain and torture to Kay Baker?
Objection.
Legal basis.
Reproach.
It's sustained.
Thank you.
How would you describe the pain that was inflicted upon Kay Baker based upon the wounds that you found?
Objection.
Overruled by law. You can answer.
Okay. So again, since the brain and the spinal cord were not transected, that allows her nerves to be functioning. She would be able to feel pain.
And she was able to feel the pain in each and every one of those wounds?
Yes, sir.
If I can have a moment, Your
Yes.
Honor. All right, thank you, Dr. Perkins. I have no further questions at this witness.
Cross-examination?
Thank you. Good morning, Doctor.
Good morning.
When we talk about the large neck wound, I guess we're referring to the one that we are all aware of at this point, right?
Yes, sir.
The large neck wound. Now, you did say, and you testified earlier, whether in deposition or trial, that could be one injury, right?
It could be one, could be multiple.
And you also said that that injury could render Ms. Baker unconscious immediately.
Not immediately. It did not hit a nerve structure, so it would be quick. She's bleeding out very quickly. Seconds to minutes.
When we say immediate, let's just say that she would have been unconscious within seconds.
Seconds, yes.
Okay. And you would agree that all the wounds that were inflicted here or suffered here could have been inflicted within seconds. You agree with that?
Yes.
You also agree that Ms. Baker's blood alcohol level was between 0.14 and 0.16?
Yes, sir.
So potentially twice the legal limit.
Yes.
You would agree that she probably shouldn't have been driving.
Correct.
And intoxication may have a tendency at times to dull the senses.
It can.
It can dull reaction times.
Yes.
It can slow all those things. It can affect your ability to feel and communicate. Yes?
Yes.
Right. So in some ways, we could call it potentially a crude anesthetic.
To a degree, it can
Yes.
dull some of the senses.
And you cannot determine whether or not Ms. Baker was conscious throughout these events. Like, whether it's alive is one question, right? We don't want to confuse alive with conscious, right?
Correct.
And you had no idea to what extent she may have been conscious or unconscious at any point during this assault, right?
Correct.
You also understand that, and as a pathologist, I think you tend to look at all factors and all circumstances, right? So were you aware that nobody ever heard Ms. Baker scream?
I was not aware of that, no.
That somebody heard a sound that sounded like a female, they recognized it as a female voice, but no witness has ever testified to hearing Ms. Baker scream, correct?
Not that I'm aware.
Right. So obviously, if somebody was conscious and experiencing a severe amount of pain, you might expect there to be a scream associated with that, right?
It's possible.
Or if somebody was experiencing terror or fear or observing something as being life-threatening coming towards them, you would expect some kind of scream or audible alarm, right?
If they were allowed, yes.
Especially if they were conscious.
Yes.
And you have no idea whether or not the what you have described as the fatal wound, you have no idea whether or not that was the first wound or the second wound or the last wound. You have no idea.
I can't say completely with 100% certainty that it was the first or the last.
If I could just have 1 second, please.
Absolutely.
Thank you, Dr. Perkins. I have no further questions.
Any redirect?
Yes, Your Honor, thank you. Dr. Perkins, you testified that you couldn't be sure as to the order of the wounds and that fatal wound that we talked about before, the large gaping wound.
Yes.
On the front part of the left side of the neck. How far could Kay Baker have moved, ambulated after receiving that wound?
That wound in particular, she would not be able to ambulate very far. She'd be losing quite a bit of blood at that point, not able to breathe.
Basically, nearby where she was attacked with that particular wound.
Yes.
So if let's say for the sake of my question that there is evidence that Kay Baker's blood is found at a distance, let's say 15, 20, 30 feet away or more from her final rest point. Do you have an opinion as to whether or not that that fatal wound, the gaping wound, could have occurred, let's say, 15, 20, 30 feet away from, or more away from where her final rest point?
There'd be a consistent blood trail with that wound.
Okay.
Yes.
And if there's no blood trail, then your opinion is that
It'd be very unlikely that that wound was sustained then.
you testified on cross-examination that you can't be sure as to how long it took for the infliction for all of these 20 to 30 wounds. You said it could be seconds. Assuming there is, could it be minutes?
With that large wound, there would not be an extended period of minutes after that wound was received.
Understood. I didn't ask my question appropriately. Assuming that gaping wound is not the first wound, say is the last wound, is it possible that the other 20 or so wounds were inflicted at either seconds or minutes prior to the infliction of that last wound?
Yes.
Is it consistent with or possible that those wounds could have been inflicted, the other 20 or 25 wounds, throughout that backyard of 6209 and 6207 prior to the infliction of that last gaping wound?
Yes, that's possible.
You were questioned on cross-examination about blood alcohol concentration. Based upon the findings regarding her blood alcohol concentration, did it have any appreciable effect upon her inability to perceive pain?
It may dull to a slight degree, but not a true anesthetic effect.
Right. Along with your autopsy findings regarding there were no major damage to the nerve structures or otherwise her ability to perceive events, she was conscious and able to perceive all those other wounds, including that last fatal wound. Is that right?
Yes.
That's all I have, Your Honor. Thank
May
you.
this witness be released by the state
Yes, Your Honor.
and released by the defense? Thank you, Doctor. You may step down. You may be released as a witness at this time. Ladies and gentlemen of the jury, I noticed that it is 11:30. I'm going to give you a choice. We can either take a break now, 15-minute break or so, come back and then do a late lunch, or we can start the next witness, go up till noon, because that'll be 2 hours since you've been sitting, and I don't like to keep you more than 2 hours, and we'll take a lunch at noon. So is there anybody who wants or needs to take a break now? All right. State, call your next witness. We may not finish the witness, but we'll take a lunch break at noon.
State calls Michelle Rogers.
Michelle Rogers.
Your approach, please.
Yes. And then we'll come back and we'll determine. I won't hold you too long past 12, but do not discuss the case amongst yourselves with anyone else. Do not do the research related to the case. Avoid any contact with the case. All rise for the jury. Jury is exited. Everyone may be seated. Hold on for the door to close. All right. So the issue before the court is that State, you intend to call Ms. Rogers to show her scars, or one of the things to show her scars. The defense is objecting as to the relevance of her scars. Is that a correct assessment of the issue?
Yes, I don't know how well it's going to work to show them, but at least to discuss that she has scars and show the locations to the extent the jury can see them. I think the one on her forearm is pretty clear, and she has one on her face that's pretty clear, but the other ones from this distance, I don't know if the jury's going to see them.
All right, and the objection is relevance.
Yes, Your Honor. They've already put in all of the information about the circumstances of the crime, which is what is needed to determine whether it is in fact a prior violent felony. Adding that she has scars, showing her scars, not only does that go absolutely nowhere in making any determination in regard to whether this is in fact a prior violent felony, but it also further makes the information that we previously objected to coming in the first place even more of a feature of this penalty phase.
Mr. Diaz, is there language? I haven't seen the statute. I know that you referred to it. Is there language in the statute that makes the factor of scarring relevant?
No, Judge. What I want to clarify is, as I understand things as they were left, Your Honor did not make a ruling, and so I exist in a point of uncertainty as to what the instruction is likely to be at the end. If I understand things, the defense has not even suggested, they have basically indicated that they are going to ask you to amend the standard instruction to remove the sentence that says that the offense in Michigan is a crime involving violence. Right? So something's going to have to be put in its place there. And I'm guessing we're going to have to put something in that says this crime is a crime of violence in the state of Florida, right? Aggravated battery is a crime of violence in the state of Florida. And here's the elements of aggravated battery. Well, one of those elements is going to be permanent disfigurement, great bodily harm. So I have to prove that she suffered scars. If the defense wants to bypass the notion of changing the instruction so it just says the crime in Michigan is a crime involving the use of or threat of violence, then I don't need to do this. But that's where they're indicating, and I now have to make decisions for what you might or might not decide to do later.
Well, regardless, as I sit here right now, I have no intention of amending the standard jury instructions. That is a rare, if ever, occasion in my court, because although the standard Supreme Court jury instructions are somewhere referenced as a recommendation, I've always said it's the safest route, and rarely, if ever, have I disturbed the Supreme Court's language in those instructions. But still, at some point, I would have to make the determination in order to instruct the jury on this. And it is your, and I cannot control your case decision as to what evidence you want to present during your case in chief for me to make that determination. But as we said before, or I said before, somebody has to decide that it is to put it in there. I understand their objection that it's the jury that decides. I don't know that I agree with that now because of the standard language in the instruction. But the case law says, or the instruction, the actual reference in the instruction says, that that decision must be based on evidence.
Then
I can't tell you, though, at any point whether you're here, there, or there from that evidence until I get to the charging conference and say whether. So you're on your own. As to relevance, I overrule the objection.
And Judge, I would point out, they've already put in photographs of Ms. Rogers. They don't need her coming in here portraying her scars.
That goes to whether it's becoming a feature, and as I've indicated before, that is shaky ground at best. And I'm going to overrule that, but that is always there. So I just caution the state as to whether ultimately I or someone else may consider it to have become such a feature of the state's case that it warrants either not sending the case to the jury, reversing myself, granting a new trial, or an appellate court reversing on that issue. So it's in the record.
Well, Your Honor, I guess I would ask this question of the court. If the court's position is someone has to make the determination, and I think someone does, and that determination has to be made by you, then I won't put her on in front of the jury. I would ask to call her in and proffer her so you can hear her, so you can consider that evidence. But I think the jury needs to hear it for you to ultimately consider it, because I worry that they're going to say, well, if it's a proffer, it doesn't count. So I would happily put her on and proffer her and let you take a look at her.
I can't give you legal advice.
I'm not asking you to.
I overruled their objection.
Yes, Your Honor, thank you.
All right, take a break.
And I apologize, before we take a break, I'm going to offer one more ground. As Ms. Terry stated, that they already put up the photographs with stitches and the post-operative and things of that nature.
I recall those.
Right. At this point, if the court is going to say that the scars are relevant, then we're going to argue that because of what they've already presented, the probative value of the scars, and Mr. Diaz has already admitted they're difficult to see, the probative values of scars that are not readily apparent to the jury does not outweigh the danger of unfair prejudice in parading this Williams Rule witness before the jury one more time.
Does the defense just want to concede that the victim suffered great bodily harm?
We're not conceding what we don't believe is relevant.
They proceeded their own caution. I've overruled the relevance. I've cautioned them on the feature issue. I hear your argument. It was a little bit. It's that the prejudicial effect substantially outweighs any probative value. I'm going to overrule on 403, keeping in mind that, yes, the jury has seen photographs of the stitching, and this is ultimately her testimony regarding that stitching resulted in scars. But that's
right, in addition to the cumulative nature of it.
Understand. It's overruled. I'm going to allow it. I'm going to allow them to. I'm going to allow it.
Thank you.
All right. Have a short break.
What time do we come back, please?
Let's do 10 minutes for us because it's already been a few minutes for them. So I'll give you all 10 minutes, sufficient time. Let's come back. That takes us at 11:45 and then my plan is probably to go to 12:30 till lunch break. You're welcome.
This is the video I want to introduce. I've been on my laptop just to place faster and better.
hearsay unless a proper foundation is laid.
Well,
Can't
the
lay
video
the
is
proper
not.
foundation.
I mean, I can eliminate hearsay by having them play it without any sound. The video is not hearsay.
Well, the video has to be authenticated to be played. They
Okay.
can't authenticate it.
Well, but he read a rule or a statute that said that in the penalty phase it doesn't have to be authenticated. Read it again.
Any such evidence the court deems to have probative value may be received, comma, regardless of its admissibilities under the exclusionary rules of evidence, comma, provided the defendant is accorded a fair opportunity to rebut any hearsay statements. I do not care a word about what the word people are saying on the video. I will have the video changed to have no sound if that's the case.
Judge, again, we are getting into number one, they can't authenticate it. They can claim they don't have to. The court has to still make a determination. We're not at a hearing where a jury isn't going to hear it. We're not at a motion hearing where the court's just going to hear it. We are still in trial. They still have to satisfy all of the rules. Just because it's penalty phase doesn't make anything any more admissible than it would be at trial. Additionally, yet again, we are hitting cumulative evidence, that which is making this prior violent felony a feature. It's not just a feature at this point, it's the entirety of their penalty phase presentation thus far. They have more than crossed the line for what is a feature, and at this point, we have already passed what is likely reversible error, and continuing to put things in is going to only make that even more evident to the appellate court. This video has no probative value whatsoever. The prejudice of it substantially outweighs any minimal probative value that could be found. All that is shown on that video is Matthew Terry standing in his underwear, bleeding at a prior incident that has nothing to do with the incident they are supposed to be proving, especially heinous, atrocious, and cruel, or prior violent felony for.
Matthew Terry is not bleeding. Matthew Terry didn't suffer a single injury in that attack. I'll be happy to show you every single one of the photos that were taken of Mr. Terry at the hospital. He's not injured. He's covered in the victim's blood. He's covered in Michelle Rogers' blood. That's not his blood. And I don't know how it could be any clearer that it says it's regardless of the admissibility under the exclusionary rules of evidence, and the only caveat has to do with hearsay, and I'm happy to take out any statement of any person on the video. It's just video then. It will be authenticated nonetheless by Detective Crumbach, who is the lead investigator on the case, who will say, this is the body cam video from Officer Dykins, who's not Sergeant Dykins, but Officer Dykins, on the night the defendant was arrested.
If he's now Sergeant Dykins and they believe that to be something that is relevant, which it's not, and that wouldn't make it a feature, which it would, then they could have brought Sergeant Dykins. They didn't do that. They're not satisfying the requirements for admissibility. The lax rules that they want to argue come in don't have anything to do with properly establishing the predicate for getting in things like video testimony. This is exactly why we can't rebut it, because there's nobody here to cross-examine in order to rebut it, to talk about, wait, were there actually injuries that you saw there? Counsel can say what he wants about his interpretation of medical records. That still doesn't make this any less cumulative, any more of something that would be relevant to a determination this jury has to make, and certainly doesn't stop this from becoming yet again a feature of this entire proceeding.
Judge,
Again, Mr. Diaz, just you propose that it is to show the violent nature of the prior incident. Is that correct?
that's correct.
And isn't Miss Rogers the best person to testify regarding the violent nature of the prior attack?
Judge, didn't you just 10 minutes ago tell me you couldn't tell me if I'd have gotten there all the way yet, right? I don't know if I've gotten there. Like, how do I know when I've gotten there? Like, I'm just trying to figure it out.
All right, well, I'm not going to allow the video for a number of reasons, so no to the video.
Yes, Your Honor. If you can give me a moment, I will email and update it with correct numbers for evidence to the clerk so she can print it for me.
Do you need that before we start with this next witness?
I don't need it, but I was just going to print it so everyone could have it to reference. But if Your Honor wants to proceed,
I'd like to get them in because I'm going to send them at 12:30 to
Yes, Your Honor. Whatever you want.
lunch. So let's go ahead and get them, and we got the witness standing outside.
Yes, sir.
You're welcome to continue doing that while we're getting them. Send it
I
to
can't.
the
I
clerk.
can't do it while I'm questioning witnesses.
I understand that, but I don't know how long it takes to send an email. It's going to take them time.
Yes, sir.
So if you want to stay at your computer and send the email, you're welcome to. present and seated. Everyone else may be seated at this time. Ladies and gentlemen, welcome back. So that'll be our late morning break. It's almost 12 o'clock. I'm going to ask the state to call the next witness, and we'll take our lunch break around 12:30.
Yes, Your Honor. State calls Michelle Rogers.
Michelle Rogers.
No objection.
Same ruling. Ms. Rogers, welcome back, ma'am. I'm going to swear you in again since there's been a break since your prior testimony. So if you'll face me, please, and raise your right hand. Thank you. You swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair. That microphone may need to be brought down some. It's up. It is adjustable. Whenever you're ready, Mr. Diaz, you may proceed.
Yes, Your Honor. Ms. Rogers, the wounds that you suffered, did any of them result in scars?
Yes.
Specifically, do you have a scar on your face in any place?
Yes.
Could you please point to it? And I don't know if from this distance the jury can see it, but maybe hopefully they can.
To all of them?
Just start with one of them.
So on my left cheek, I have 2 circular bite mark scars that are somewhat covered up by makeup right now, but there's 2 scars there that are visible.
Do you have any others?
There's a small stab wound scar here, another stab wound scar here, and then another scar underneath my eyebrow.
Okay, and so forgive me if you could turn your face so the right side of your face is visible. There is a line that runs sort of horizontally, almost sort of at the same level of your lips. Is that a scar?
This one right here?
Yes.
Yes.
Okay. Do you have any scars to your arms?
Yes.
Could you tell us where and maybe if you can point it out?
Can I stand up?
Yeah, you need to.
So on my right shoulder, I have the 3 stab wound scars. I have bite mark scars on my arm here, and then I don't know where this scar exactly came from, but there's a scar here as
All right, well,
well.
we'll set that one aside if you don't know where it came from. But as far as the ones that are
Well,
directly...
from this, I just don't know what.
I got it. But at least as far as the other ones, you know exactly what they're tied to. Those are all scars that are resulting from the incident that happened with Matthew Terry in Lansing.
Yes, that's correct.
I don't have any questions.
No question.
All right. May this witness be released by the state
Yes, Your Honor.
and by the defense?
Yes, sir.
Thank you, ma'am. You may step down. You may be released as a witness at this time. I'll ask the state to please call your next witness.
Your Honor, the state calls Detective Matthew Crumbach.
Detective Crumbach.
Yes. Judge, did I leave any pictures with you up there?
I don't see any.
My packet of pictures has disappeared.
If you left it on this desk, that would explain, but I don't see them. Things disappear on this desk.
Well, they're not in there.
Ms. Ismer should have them. Detective Crumbach, good morning and welcome back.
Good morning.
I'm going to swear you in again since there's been a break since your prior testimony. If you raise your right hand, please. Thank you. Do you swear affirm any testimony you give in the proceedings with the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you, sir. If you'll follow the bailiff now. Oops. Watch your step. Back to the chair, and the microphone is adjusted. You find the photographs, Mr. Diaz?
Yes, Your Honor. Thank you. Morning again, sir. State your name for the record.
Matt Crumbach.
I'm assuming nothing has changed in your employment since we last talked.
It has not.
All right, I'm just going to approach you and show you a series of photos that are marked States Exhibit 70A. Did you have a chance to look at these before you came to the witness stand?
Yes, sir, I did.
And do those photos fairly and accurately depict the condition of the home at 626 Worthington as part of the investigation that you conducted on March 17th of 2017 involving Matthew Terry as the suspect?
Yes, sir, they do.
All right. At this time, I move into evidence States Exhibit number 70A through Q.
Other than we previously discussed, any objection? All right, same ruling. I'll admit them at this time. 70A through Q admitted.
And Detective, the jury will have these to take back, so I'm not going to go through every single one of them, but just to orient us a little bit, this is State 70. What are we looking at here? 70A.
This is the interior of the residence of 626 Worthington. This is the area that the living room meets the kitchen floor area.
Okay. And over here to the right side of the end of the island or the bar, the breakfast bar area of the kitchen, there's a white object on the ground. Is that this same area here in State 70D?
Yes, sir, it is.
And I know that there was no DNA testing done on any of this, but having been there at the scene, this stuff that is sort of speckled on the edge of the wall, was that red?
Yes, sir, it was.
Did that appear consistent with potential blood?
Yes.
Here's State's Exhibit 70J. What are we looking at here?
This particular picture demonstrates or shows the garage, and in the middle of the picture is a garage door opener button, and there appears handprints on the button,
Okay.
and lower another handprint on the wall.
And I want to draw your attention to the door there. If you went through this door, do you enter into this same area right here that is depicted in 70J?
Yes, sir, that is correct.
So if you wanted to go from this area depicted in 70A, if you want to go from this area depicted in 70A to the garage, you would proceed through the door that is depicted in 70J?
Yes.
Here's State 70M. Is this the residence at 626 Worthington that was occupied by Michelle Rogers and Mr. Terry?
Yes, sir, it is.
And I'm going to just show a brief overall. This is State 70N, as in Nancy. Is this a shot of the driveway area of the home at 626 Worthington?
Yes, sir, it is.
Detective, in Michigan, do they do things slightly different where they allow the detective to sit at trial counsel with the prosecutor in the trial?
Yes, the lead detective normally does that.
I'm sorry?
Objection.
Legal basis? Well, I don't know what the question is yet.
I'm just asking if they permit him to do so.
I'll allow that. Overruled.
Okay. Were you sitting at counsel table on the day that the verdict was read in the case against Matthew Terry where Michelle Rogers is the victim?
Yes, sir.
Was he found guilty?
Yes, sir, he was.
Pass the witness, Your Honor.
Cross.
No questions?
May this witness be released by the state
Yes, Your Honor.
and the defense?
Yes.
Thank you, Detective. You may step down. You may be released as a witness at this time.
Thank you, sir.
I'll ask the state to please call your next witness.
Yes, Your Honor. State calls Ailish Gallagher.
Ailish Gallagher.
Gallagher.
Sorry. Miss Gallagher, good morning and welcome. If you'll come forward to be sworn as a witness. Wherever you're comfortable, if you'll please face me and raise your right hand. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair. Go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. You may proceed.
Thank you. Good morning, ma'am. If you would introduce yourself to the jury.
Hi, Ailish Gallagher. I'm Assistant Prosecuting Attorney in Ingham County, Michigan.
And does Ingham County, Michigan include the city of Lansing?
It does.
Were you, well, I guess first off, let's talk about when did you become a prosecutor?
I became a prosecutor in my office in June of 2014.
And so have you been a prosecutor for roughly the past 8 years?
Correct.
what is the, are you still currently prosecuting cases in Ingham County?
Correct.
Were you the prosecutor who was assigned in the case against the state of Michigan against Matthew Robertson Terry for an event that occurred on March 17th of 2017 where the victim was Michelle Rogers?
Yes,
And were you the prosecutor who ultimately took that case to trial?
I was.
Was Mr. Terry ultimately convicted of the crime of assault with the intent to do great bodily harm less than murder?
He was.
Now I'm going to show you what's been pre-marked as State's Exhibit number 69. Take a look at that. Is that an official court record from the clerk of Ingham County reflecting the conviction of Matthew Terry for the crime that I just read into the record?
It is.
Your Honor, at this time I would move into evidence State's Exhibit number 69.
Any objection to 69?
No, sir.
69 will be admitted.
All right, ma'am, I'm just going to ask you to first help the jury read this, even though I think it's pretty self-explanatory, but just in case. Here we can see at the top the defendant name, Matthew Robertson Terry, and his date of birth. Is that correct?
Correct.
And then it says prosecuting attorney Carol Seaman or Simon. That is not you. Who is that?
Correct. That is the elected official. Everyone in my office works under her. We're all assistant prosecuting attorneys, and that is our boss.
All right, so everybody is prosecuted under the name of the actual elected official, but you're the person who's handling the case.
Correct.
All right, and so it then beneath that says the court finds, one, the defendant was found guilty on October 6th, 2017. Is that the date that he was found guilty by the court?
Yes.
And then it says he was, count one, jury guilty, assault with intent to do great bodily harm less than murder, and it references this number, 750.84. What is 750.84?
So Michigan has compiled laws. So 75084 would indicate that that is assault with intent to do great bodily harm less than murder.
Okay, and so I want to ask you, in the state of Michigan, do you have charges divided up into what are known as felonies and misdemeanors?
Correct.
And is assault with the intent to do great bodily harm less than murder a felony?
It is a felony, yes.
All right, and I'm going to show you this and tell me if you recognize it. I'm going to zoom out so everyone can see it first. Does the Michigan legislature, aka the people that write the laws in Michigan, do they maintain a website where you can refer to the Michigan penal codes?
They do. I refer to it often.
And so is this the correct Michigan Penal Code 750.84 for the crime of assault with the intent to do great bodily harm less than murder?
It is.
Okay, and so I want to talk with you about the word assault. I don't know that Florida and Michigan use the word assault the same way. Can you tell us, does an assault in the state of Michigan contemplate someone touching, striking, or causing harm to another person?
Yes.
I mean, if I run up to somebody and I hit them, does that constitute potentially an assault?
Correct.
If I was to get a car and run somebody over, would that potentially be assault?
Yes. It could be a plethora of charges in Michigan.
Right, I got it. I'm sure it could be a lot of things if I hit somebody with a car. But I mean, the important part is, for purposes of Michigan, the word assault contemplates touching or hitting somebody.
Correct.
Okay, because in the state of Florida, for example, we don't define assault that way. So we would call that battery. Do you understand?
In Michigan, we say assault or assault and battery
Okay.
as
so-
one term under a penal code.
Right, and that's what I want to highlight. The states use the phrases somewhat interchangeably. Is that fair to say?
Very fair.
But in your state, assault means touching or hitting somebody. Okay, and then what it shows is a person who does either of the following is guilty of a felony, and it says assaults another person with the intent to do great bodily harm less than the crime of murder. So would that include things like stabbing someone, injuring someone with a weapon, things of that nature?
It can.
And so is that the charge that ultimately Mr. Terry was found guilty of in relation to the injury that was caused to Michelle Rogers?
Yes, the jury found him guilty of assault with intent to do great bodily harm less than murder.
Sorry, have a moment, Your Honor.
Yes.
Pass the witness, Your Honor.
Cross.
No questions.
May this witness be released by the state
Yes, Your Honor.
and released by the defense?
Yes, Your Honor.
Thank you, ma'am. You may step down. You may be released as a witness at this time.
Thank you.
You're welcome. Mr. Diaz, I'll ask the state to please call your next witness.
Your Honor, can defense and I approach?
Yeah, absolutely. Since I told you lunch by 12:30, and it is 12:15, give you a lunch break, I'm going to give you till 1:30. Please do not discuss the case amongst yourselves with anyone else. Please do not do any research related to the case, and please avoid any reports of the case outside of the courtroom. Please have a nice lunch. We'll see you back here at 1:30. All rise for the jury. You can move over here and sit right next to me. Exited. Everyone may be seated, and the door is closed. All right, so we're going to talk about the victim impact witnesses or statements, and apparently there's some objections, and you indicated that there might be two versions, or one with the objections.
Yes, Your Honor. So I'm going to first give you Kelly Andrews. It's the shorter one, so you can read along.
And just for the record, tell me who Kelly Andrews is.
Kelly Andrews is the witness who already testified. She is the friend who was at the landing bar
Oh,
that
right.
evening.
She testified in the guilt phase.
And so Mr. Kane has his paper where he highlighted several statements. We already discussed this one previously, and some stuff I agreed to, and there's still a few other things that
All right, let me read it just so I have it. It's only 2 pages, so it'll take me a second. But I'm in a better position if I digest the whole thing. If I read the whole thing. The 2 pages. Mr. Kane, what are the objections to this victim impact statement by Kelly Andrews?
Have this conversation at the bench, please.
Sure.
just will need a little bit more than 5 minutes to actually make
that the jury is all back. What I want to do is we provided a copy of, I went through all of the objectionable language and essentially ruled on it by highlighting what I was agreeing to take out. I just want to say on the record that given the status of the law, this is a difficult decision regarding what can be said and what can't be said. Certainly anything that I've eliminated is not something that can and necessarily should be considered either at a Spencer hearing if one becomes necessary, or certainly at a sentencing hearing where the spectrum is so much wider. But there was still a significant amount left in the victim impact statements that is going to be presented to the jury, and I do believe that all of that is left falls within the parameters of the law as being permissible. What I'd like to do, Mr. Kane, I have in my hand your copy that had all of the pink highlights. That's what you suggested. What I did is I then yellow highlighted over what I agreed to. What we provided to you was just the yellow highlighting as to what's coming out. I would like to make this a court exhibit, if you don't mind, so that there is a record of what the defense specifically requested to come out and specifically what I ruled. If you'd like to take a look at it to see that it is exactly how I'm explaining it, you're welcome to do that. Is there any objection? It's yours. So, technically, I guess if you want it back, I'd have to give it back to you. But do you disagree with making this a court exhibit?
No, sir.
Before?
No, sir.
Mr. Diaz, any objection?
Not at all, Your Honor.
Anyone need to look at the two different versions of the highlighting, the pink and then the yellow over the pink?
No, Your Honor.
Right, and obviously the pink is what we had moved to exclude, and the yellow over the pink
Is what I agreed to exclude.
Yeah.
So certainly you would maintain any objection
Right. Kinda looks
to what
orange
is
from here.
pink.
Right, it looks a little bit orange, so I guess that I'm just
Here, go ahead and
making
take a
sure
look
we
at it. Yeah, it
understood.
becomes kind of orange when the yellow is highlighted over it. But certainly you would maintain any objection to anything that is pink but not covered in yellow because you wanted that withdrawn or taken out, redacted, and I did not agree to it.
Gotcha.
So there is now a court exhibit of what you were objecting to
Yes.
that I both agreed to and what I did not agree to.
Yes, sir.
All right.
That's clear.
Madam Clerk, court exhibit 4. Number 4. All right. Anything else? Statement? Defense ready?
Yes, that's correct.
All right, let's get
I think by agreement from the defense, I'm going to admit the last 3 exhibits, 71, 72, and 73. They're all photos of the victim that I'll be.
You introduce them through some of these witnesses.
I think the defense is not disagreeing to their admission. I was just going to move them in.
You want to move them in now?
I would admit States Exhibit 70.
1, 2, and 3.
Yes, and let me just read the letters into the record. 71 is 71 is photos of Kay Baker with her friends. That's A and B. 72 is photos of Kay Baker with her family. That's A through D, like Delta. And then 73 is a lone photo.
So we don't need to, we just leave it 73.
It's just 73, yes.
A on it. All right. Any objection to those 3 exhibits, 2 of them which are composite?
No objection.
All right, they will be admitted. 71, A and B, 72, A through D, and 73. Admitted.
Thank you. I'm going to go ahead and retrieve them. I'll read them again in a second.
Can you start lining them up?
And actually, before they come out,
Go, wait.
we are,
Probably.
I don't believe we have defenses. Defense 1, and we'll fill out the cards. Defense 1 is the pen pack from the Michigan Department of Corrections.
I don't have any objection to it.
All right, defense one will be admitted.
Offense 2 is the certificate of discharge, not the DD 214, but the certificate of discharge from the United States Marine Corps, Matthew Terry.
No objection.
Defense 2 is admitted.
Offense 3 are certified transcripts from Western Michigan University.
No objection.
Defense 3 admitted. So let me ask the defense, does that mean that you're ready once the state has called these two witnesses that I suspect will go fairly quickly, so that there's no need to take a break and I just turn to the defense and ask you to start calling witnesses?
Yes, I've asked that our witnesses come over and wait in the witness room, so hopefully, they're just right across the street there at our office, so there shouldn't be a problem, there shouldn't be any issue.
Mr. Diaz, roughly how long you think that they're just reading these statements, right?
It's just the two witnesses. They're reading the statements, and other than just asking them who are these people in these pictures, just to explain them, that's it.
All right, then you're going to rest.
Yes.
And then I'll turn to the defense, and if we need to take a break, they're not here, I mean, that's fine, but if not, it sounds like we're ready. You've got your exhibits in. Any other exhibits you intend to offer that have not been agreed to?
The defense showed me a variety of photos. The defense showed me a variety of, they're over there redacting things, I think, now. I'm not sure what they're doing.
Taking out the social security number, which
Well, that's fair.
statute has to be.
Yeah, I got no problem with that. The defense showed me a variety of photos of the defendant. It wasn't clear which ones they were or not going to use. As a general rule, I don't have any objection to putting in photos of the defendant. There was one photo that was just his daughter that he's not in, and I objected to that one. But there are photos of him with his daughter. I don't have any objection to those.
Okay. Do you anticipate any issues over the photographs?
No.
Okay.
I mean, I will ask to see them before they finally select what they are putting in, but what they just kind of skim through, I have no problem.
And Mr. Diaz, we're redacting from the pen pad any reference to dismissed charges.
Agreed?
Yeah, that's fine.
Okay. All right, can you start lining them up? Defense? Can you start lining them up?
Yes, that's fine.
Give it.
Judge, do you want me to move the three exhibits I admitted into evidence in front of the jury?
That is up to you.
Okay, I will do that then, just very briefly.
Yes.
All rise, jury, and court.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Good afternoon. Hope everyone had a nice lunch. We're going to now pick up where we left off, and I'm going to turn to the state and ask them to please. Well, you know what? I forgot to ask. Did anybody discuss this case amongst yourselves or with anyone else during the break? Did anyone have, and let the record reflect there are no hands, did anyone see any reports about this case, have any contact with anything about this case between the time that we broke for lunch and the time that you've returned at this time by show of hands? Thank you again very much. Let the record reflect there are no hands. Appreciate that. Mr. Diaz, you may call your next witness.
Just very briefly, I was moving to evidence State's Exhibit number 71, A through B, 72, A through D as in Delta, and State's Exhibit number 73.
Any objection?
No.
All right, those will all three exhibits be admitted.
Your Honor, at this time, State calls Kelly Andrews.
Kelly Andrews. Miss Andrews, a good afternoon and welcome back, ma'am. I need to swear you in again since it's been a break since your last testimony. If you'll raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead and have a seat, ma'am. Make yourself comfortable. That microphone is fully adjusted.
Ms. Andrews, just very briefly, I know you brought a statement that you're going to read from in a moment, but just very quickly, I want to show the jury State's Exhibit 71A and B. Is this you and Kay Baker? And then here State's 71B. Is this you here next to Kay Baker in this bright yellow top?
Yes, it is.
And these all her friends?
Yes, it is.
All right, my understanding is you brought a statement, so if you would, please read your statement.
Hello, my name is Kelly Andrews, and I am one of Kay Baker's best friends. I knew Kay Baker first as a teacher, then a friend, and then as a mother. As teachers, we give so much of our lives helping children that aren't our own. Kay worked at a school with a very diverse demographic. Many of our students over the years didn't speak much English, had learning disabilities, and mental and emotional imbalances. She spent years never leaving the same school. Not only did she embrace these children, she was able to connect with them and push them to achieve success. Her math scores for her students were so high, she grabbed the attention of our district superintendent. He actually came out to her school in Ruskin just to see her in action. Kay was not only an amazing friend, but one of my best friends. She was the kind of friend that never judged and always listened. Kay always had her own opinions, but would always give good advice. She always had your back and was there in your darkest times. She was there for me during a very dark time when my son was in the hospital. His mental health wasn't good, and her amazing advice and support was what I needed. Her friendship meant everything to me, as it did to many others. She made friends wherever she went, and it just attracted people with her quick-witted personality and fun-loving personality. Kay had special bonds with so many people. Her death has caused so much pain and anguish. As one of the last ones to see her and hear her voice, there is an ache in my heart that never seems to go away. There is a missing piece of a puzzle in every circle of our friends, puzzles that are now forever incomplete. And finally, as a mother, her boys meant everything to her. She had told me that she had always wanted to be a mom. Kay sacrificed for them, as many mothers do, and embraced all the highs and lows of parenting. She did and would do anything for her children. She kept a friendship with her ex-husband just so her boys would know that their parents still liked each other and would always be their parents. They would still have family days together, celebrate holidays together, and were their biggest fans at their soccer games. They were the best co-parents I know. Kay loved watching Nicholas and Mason grow and created cherished memories with them. The best part was the way they showed their affection to each other. They would crawl up into her lap for snuggles and look into each other's eyes. Now they can't do that. Mason and Nicholas will have to hold on to those memories and hope that they will never fade. They will have to go on with their lives without their mother. This will forever be a hole in all our hearts that will never be filled. I will never be able to speak to her or hear her voice again. The anguish of her dear friends and, more importantly, her family are indescribable. This devastation is unbearable. The unfairness of her death is unreal. We all loved her so much.
Any cross-examination?
No, sir. We can
You
just
may-
approach briefly, please.
Yes, you may. You may step down.
Yes.
Released by the state
She is free to go, Your Honor.
and released by the defense?
Yes, thank you.
Then you may, yes, you may. State calls Kerry Rebold. Ms. Rebold, I'm sorry. If you'll raise your right hand, please. Thank you. And good afternoon and welcome. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. If you'll follow the bailiff now, please watch your step. When you get to the chair, go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. Let me know when you're ready, and then I'll allow the attorneys to proceed.
I believe I'm ready.
All right, Mr. Diaz, you may proceed.
Ms. Rebels, just very briefly before you read the statement that you came with, I want to show you State's Exhibit number 73. Is this your sister?
Yes, it is.
And then I'm going to show you a variety of photos that are in State 72, and if you could just tell me who the people in the picture are. This is 72A. Who are we looking at here?
On the left is my sister Paula. She is the middle sister. Kay is in the middle. She's the youngest sister, and then that is a picture of me. I'm the oldest sister.
Here's state 72B as in boy. Who are we looking at here?
The young lady on the left is my son David's girlfriend, Kristen. Next to her is my son David. Then there's a picture of me. Slightly behind me is my husband Chris, my daughter Kate, my sister Kay. In the back is my dad, Dave. In front of him is my youngest son Alex, and then my stepmom Chris.
Who are we looking at here in state 72C?
That is Kay and her youngest son Nicholas.
And who are we looking at here in state's exhibit 72D?
That is Kay and her oldest son Mason.
All right, ma'am, you brought a statement here today. I would ask you at this time to please read your statement.
Good afternoon, Your Honor. My name is Carrie, and I'm Kay's oldest sister. This means that I knew Kay for her entire life. And I definitely remember the morning of May 28th, the day my dad called to tell me that Kay was dead. I'm grateful to the court for the opportunity to speak today to share some of my memories about my sister Kay, to talk about who she was as a person and what her loss has meant to us, her family. I am speaking today for our whole family, for my dad, my stepmom, my sister Paula, Kay's nieces and nephews, and for Kay's two young boys, Mason and Nicholas. It's a difficult thing to put into words the importance of a sister, a daughter, a mother. To explain to strangers what someone meant to you, how that person uniquely fit into your family, and how your family will never, ever be the same because that person is gone. It feels like a tremendous responsibility to choose the right words, to get it right, to do her memory justice, so that you can know her as we did, even just a little bit. In September, we had a party in Michigan, which is where our family is originally from, to celebrate Kay. I think she would have really liked the party. There was good food, music from the 60s, which is what we grew up listening to as kids, her best friends, and so many family members. I know the more popular term is to call these events a celebration of life. But I struggle with saying these words because it reminds me that we were celebrating her life because it had ended. So I prefer to think of it as the party we had for Kay. There are a lot of words that spring to mind when I think about Kay. Vibrant, lively, warm, funny, feisty, genuine, strong, stubborn. My sister was all of these things. If I had to pick out just one memorable thing about Kay, it would be the energy she brought into the room with her. It is an intangible, impossible thing to describe, but real nonetheless. It was her gift. She drew people to her. She always had a smile and was quick to point out the humor in everyday life. She had a way of making everything more fun. She was a marvelous instigator of silliness with her friends and family. I will definitely miss this part of her. It seemed completely reasonable to climb into the giant swing at the park, to squeeze ourselves into giant tortoiseshells to see how heavy they were, to take silly pictures of ourselves peeking out from behind trees and plants. Sometimes during her visits, at around the time everyone would be thinking about going to bed, she would get what she called her second wind. We would all roll our eyes in fear and prepare to stay up just a little longer and to have just a little more laughter. The world is certainly a little less sparkly without Kay, and the world misses her laughter, I am sure.
Ma'am, if you would, could you pull the microphone just a little bit closer to me? It's hard to hear.
Oh, sorry.
It's okay.
Kay was loyal to the people she loved. She always made time for her friends and family. Not always an easy thing to do, as much of our family and many of her friends were long distance. I think her favorite thing to do was to just get together and spend time with friends and family. This could be at a restaurant with friends, on a deck overlooking the lake at my dad's cabin in Canada, or just around a kitchen table. As long as she was surrounded by friends and family, she was happy. Our family usually gets together the week after Christmas with Kay and her boys. There will be an emptiness this holiday season that will be hard to bear. Kay was a strong, independent person. She wasn't afraid to make tough decisions, and she wasn't afraid to change direction and pick a new path in her life in order to make something better. I've always admired her for this. When she graduated from high school, she decided not to go to college because it wasn't the right thing for her to do at the time. A few years later, when it was the right time, she made it happen and graduated with the highest honors. She wasn't afraid to move to Florida 15 years ago to start a new job when she didn't know anyone. She built an amazing life here. She made wonderful, loyal friends by being a wonderful, loyal friend herself. When her marriage didn't work out as she had hoped, she picked a new path that involved becoming friends with Kevin, her ex-husband, and learning how to be half of a really effective, good co-parenting team. I admire her strength to turn something as difficult and painful as divorce into something positive for herself and her boys. Kay always loved babies and children. She made friends with neighboring families and acted as a mother's helper. The kids loved her. She loved the kids. In high school, she earned money babysitting, but it was far more than a job for her. She was really close with the kids and stayed in touch with them, long after she stopped babysitting for them. Her first job after high school was working in daycare. If it paid more, she may never have left that field. When she decided to go back to school, she studied elementary school education and has been a third-grade teacher at Cypress Creek Elementary School ever since. She loved being a teacher. She enjoyed watching the kids grow and learn and was proud of the kids when they did well. She was an amazing aunt and spoiled each of my 3 children shamelessly. But it was having her own kids, Mason and Nicholas, that made her the happiest. I don't really have the words to articulate how much she loved being a mom, how proud she was of her kids, how she had hopes and dreams for her boys, as we all do for our own children. How can you possibly describe the love a mother has for her sons? I think there just aren't big enough words to describe it. Being a mom was the most important thing in Kay's life. The loss of Kay to our family is profound. My dad has lost his youngest child, and my stepmom has lost a daughter she helped raise. Parents are not supposed to outlive their children. For my parents, there is no escaping the pain. They must bear it because there is no choice. My sister Paul and I have lost a sister. There are no words to describe the void that her absence brings. Today, I stand by my sister. I miss my sister. My sister has 2 young boys. Mason is 9, and Nicholas is 6. My sister Kay is irreplaceable. To me, to my parents, to my sister, to her friends, and to her sons. She is loved more than she will ever know. She will not be forgotten.
Thank you, ma'am. Pass the witness, Your Honor.
Thank you, ma'am. You may step down. May she be released by the state
Yes, Your Honor.
and released by the defense? Ma'am, you may be released as a witness.
Your Honor, at this time, just stay rest.
All right. I do have an instruction, ladies and gentlemen. You have heard evidence about the impact of this murder on the family and friends of K.E. Baker. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by K. Baker's death. However, you may not consider this evidence as an aggravating factor. We'll now turn to the defense, and I'll ask if they're ready to proceed with the defense case.
Yeah, if I just have 1 second.
Certainly.
Just step out in the witness room real quick.
Bring your first witness in with you when you come back.
Thank you.
Ms. Perry, do you know the name of the first witness?
I believe I do, but he may change
All right.
course.
Okay.
so-
Not a problem. It's not a problem. Mr. Kane, who is your first witness? I'm sorry?
That's called Mark Terry.
Mark Terry? Mr. Terry, if you'll come, you can come forward. Keep walking wherever you're comfortable. If you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll follow, you can put your hand down and follow the bailiff. Please watch your step. Go ahead, make yourself comfortable in that chair. The microphone in front of you is fully adjustable. You let me know when you're ready.
I'm ready.
All right. Mr. Kane, you may proceed.
Thank you. Good afternoon, Mr. Terry.
Howdy.
Now I'm going to ask you to speak up very clearly and talk into the microphone. Sometimes it amplifies, sometimes it doesn't, but we just want to make sure that you can be heard, okay? If you can introduce yourself, please.
My name is Mark Terry.
And how are you related to Matt?
I'm his father.
And where are you from?
East Lansing, Michigan.
And tell us a little bit about yourself. I mean, what you do for a living and
I'm currently retired, own some real estate. I was a commercial lender before I retired.
are you married?
Going on 50 years.
Okay. And what's your wife's name?
Kathy.
Is she here with us in Florida
She
right
is.
now? Where are you all from?
She's from East Lansing. She grew up in East Lansing. I grew up in the Detroit area. Went to Michigan State and married a local.
All right. So tell us about your marriage a little bit. You and Kathy stayed in the Michigan area where you all are from. Is that correct?
Correct.
All right. And did you have children?
3 boys.
Okay. And what are their names? I know we know Matt.
Matthew, Luke, and Peter.
Who's the oldest?
Matt.
What's Matt's birthday?
January 14th, 1975.
Now, you see Matt in the courtroom today?
I do.
All right. Can you point him out?
Right there in the tan coat.
When's the last time you saw Matt?
Would have been sometime in January or February of this year.
And obviously, I think you visited him at the jail. Is that correct?
I did. I forgot about that. Yep. Visited in late May. No, it would have been July. Excuse me, in July.
Okay. I think you had come down to pick up his car and things of that nature.
Correct.
And while you were here, you visited him at Falkenberg Road Jail.
Correct. It was a video visit, so I'm not.
Okay.
I could have done that in East Lansing and it wouldn't count it as a visit, but I was here.
All right. When's the last time you were in his physical presence? You guys were able to give each other a hug. When's the last time that happened?
That would have been February of this year,
Right before he moved down to Florida?
just before he moved down. Correct.
All right. Now, tell us a little bit about Matt's upbringing, and obviously you had Matt in 1975. When you all had Matt, how long had you and Kathy been married?
We were married in August of '73, so it'd be about a year and a half.
Tell us about Matt's upbringing, about his childhood, what kind of child he was, and some of the things that he found interesting, and what you all did together, and how that went as your family got larger.
Matt was a great kid, beautiful baby, very patient, but also very precocious. You might even say impulsive, but I'm talking when they were 2, 3, 4 years old. And when you got them all together in a room, it was, 1 + 1 is 12. They were a handful, but they got along great, and they had very happy childhoods, all three of them.
Was that in East Lansing and also in other parts of the state?
Well, we were in East Lansing for the first maybe 7 or 8 years, and then we moved to Detroit briefly for about a year and a half. It was a transfer for my work, and then we had bought a cottage on a lake in 1979 that needed a lot of fixing up, so we decided just to move there. And because I grew up near a lake, and I knew it was a great place to grow up, so we moved the kids in 79. No, it would have been 84, excuse me, that we moved to the lake.
That was in Holton?
Holton, yeah.
And that's the series of blue lakes in and around that area. Is that what it's called?
Big Blue Lake, yep, is where we lived.
Now, how did you and Kathy view, being parents and responsibilities that came with that? How did you guys sort of respond to one another and respond to your kids in terms of your parenting responsibilities?
Well, raising kids was part of getting married, and getting married was part of our relationship. And, having children is a great way to learn a lot of stuff about yourself because they imitate you, and sometimes it's shocking and instructive. So, I would say it was a very shocking, instructive, enjoyable, fun time.
And what were some of Matt's interests as he was getting older? What developed?
Well, I'm not sure what age you mean, but we were at the lake from '84 on, so he would have been 9, and he was very much involved in the outdoors, everything but the woods and the water. Loved to fish, did a little bit of hunting, but mostly fishing.
Ever any sort of issues or problems that you had behaviorally as he was, going through elementary school or going through junior high school? Anything that stands out as especially concerning?
There was never anything that was concerning. There were always issues. As there always are with kids.
But nothing that you viewed as extraordinary?
Nothing extraordinary at all. I had my issues as a teenager, but so did all my friends. Nothing out of the average at all.
When you were raising your boys and they were sort of going through their school age years, I guess you also met Ben and Ruby Williams, right?
Correct.
Right.
Neighbors.
Okay. Can you talk to us about how those relationships developed and how they became meaningful?
Well, in our case, most of our close relationships developed with people who had kids the same age as ours, because you ended up, in the same places and at the same times, sitting in the bleachers or whatever. In Ben and Ruby's case, they also were only 2 or 3 doors down. So, and they had a couple of kids the same age as ours, and they developed very good friendships. And they were playing around when they were when they were 4, 5, 6, 7, and beyond.
And obviously that would have been in East Lansing, right? That's
Correct.
Before you moved to
the lake, right?
to the lake. And how did your boys, or how did Matt react to the move from East Lansing to Holton?
Well, there was a move to Detroit in between, and the move to Detroit was not really welcomed. It was, he went where mom and dad went. And we had some friends there that had some girls that were good friends of theirs. And so they had people to hang with, but they loved to move to the lake.
How would you say that Matt was unique for, compared to his brothers? What set him apart from either Luke or Peter?
Matt was much calmer, quieter. He was the shyest of the three. And I'd say he was more patient. He was the most patient. I remember once Matt and Luke were fighting over something, and it was a pretty intense, as brothers do. And so I got in there to referee, and I said, okay, we'll flip a coin. Whoever wins gets it. And they both said, okay. I flipped the coin, and Matt had won, and Luke went berserk. He wanted to reflip, etc. Other times, if Matt would lose, he'd just say, "Oh, okay," and move on. So Matt was not as competitive, but much more patient and calmer, I think.
How would you characterize his obedience when you guys would tell them what they can and cannot do, or you would set ground rules or limitations? How did Matt respond to those?
Very well. That mixed, you had to mix that in with a highly inquisitive and impulsive nature, but he was also very anxious to please all the time.
And you described a couple of personality traits there, the inquisitiveness, the curiosity. And how did that fit into his personality?
At the forefront. I mean, it came up all the time. We were at a friend's house, and one of the gentlemen was a butcher who was as round as he was tall. Matt was about 7 or 8 years old, and he walked by while the guy was getting dressed, and he stared at him, and he said, "Who makes your pants?" And that's just the way he was. He'd see things, he'd question it, and
so he was very, very vocal about his curiosities.
Yep.
How about in his relationships with others? Were you ever concerned that Matt had an inability or any sort of obstruction in relating and getting along with others, or did it seem to come easy for him? Was it difficult?
He was very, very shy. So he made close friendships, but it took time.
Did you ever observe any personality traits in his childhood that you don't believe he has as an adult? Or has it pretty much been consistently the same, just with a more an adult perspective? I mean, how would you characterize him that way? Well,
kids mature as they grow and mature as they develop, and so traits, you can see the root of all those traits, but they obviously don't look the same as they would on a 3-year-old.
With Matt, what would you say are his enduring traits, those things that he possessed in childhood that he still possesses?
Curiosity, willingness to please, I think still kind of shy.
At some point, Matt had a daughter, right? And that would be your granddaughter. And can you tell us about Jessica and what Matt and you, pretty much your whole family, went through in more or less rescuing her from very unfortunate circumstances?
Sure. Jessica was born in 1998, I think it was 98, to a girl that Matt had been living with down in North Carolina. It was not she's a beautiful, beautiful little girl, but it was not necessarily a good living relationship, and Matt recognized that. He was living with Nikki, that was the gal's name, and her 3 brothers, and I believe they were all from different fathers. There'd been some sexual molestation issues, and Matt wanted Jessica out of the house, out of that situation. Jessica's stepfather, or Nikki's stepfather, would be Jessica's step-grandfather, told me point blank, this is no place to raise a little girl, get her out of here. So there's a lot of stuff happening in between here, but we invited Nikki to come stay with us in East Lansing. We were thinking that a relationship might still develop between Matt and Nikki. And she took us up on it. She was going to maybe go to school, etc. And then Jessica and Matt and Nikki would live with us until something changed. So they were up in East Lansing for probably at least 12 months. It might have been longer. It didn't turn out to be a relationship between the two developed. It kind of soured and went the other way, but they were still civil and fine. But Nikki abruptly left the house and took Jessica with her and went back to North Carolina. And Matt could have just dropped it right then, but he was very concerned about her environment down there. So he was putting himself through school at the time, working part-time and going to college on the GI Bill. And he got an attorney and sued for custody of Jessica, which, a single father generally has trouble doing that. But he was successful, got a judgment in Michigan, because that's what had jurisdiction, because they had most recently resided there. And then the next task was to try to execute that kind of a writ in another state. That was very difficult, but he found an attorney that had Lansing roots, had gone to Cooley Law School, and was very helpful. And they coordinated it, and he was able to go with his brother Luke down there, and it took him a couple days, but they ended up with the sheriff, and they were able to get Jessica and bring her back to Lansing.
How old was she at the time?
3, maybe. I'm guessing 3-ish.
3 years old.
3-ish, yeah. And she, that was the first time. She grew up there and was a very happy child until, probably until she hit 16. Michigan has a difficult situation for parents, because at age 16, children are able to do whatever they want to do, go wherever they want to go, but parents are still liable till they hit 18. So Jessica was very precocious as well, and she had decided that she wanted to leave the house, run away. Kids always want to run away, so she ran away. She was about 10 blocks away, but Matt was, of course, semi-frantic because he didn't know where she was. A sympathetic East Lansing policeman went out of his jurisdiction, and he found her, and he sort of coaxed her back after a week. So she came back to the house, but she said, I want to go back and live with my mom, and you can't stop me. So he, by that time, recognized that was true, so we called Nikki in North Carolina, and she came up, and she was not anxious for this to happen. She had remarried and just had a new baby and had a new life, and all of a sudden, Jessica was saying, take me back. So Nikki came to East Lansing with her husband, and they talked about it, and they said, sure, we can do that. We'll send her to school. It's right across the street. We got a nice new apartment. He managed the apartment. Everything's great. So, again, reluctantly, Matt said, sure, go ahead and do that. Shortly after she left, and I'm a little fuzzy on this part, but he wasn't hearing from her as often as he'd like. He was just getting texts, and he could never get her on the phone. He just got texts saying, don't worry, I'm okay, everything's fine, blah, blah, blah. And then he got an anonymous message on Facebook that said, your daughter is staying at this house, bad things happen there, you need to get her right away. But he didn't know what house or whatever, but then he really started looking into it, and he called Nikki and demanded to find out where she was. Turns out she'd been kicked out of the house shortly after she got there, and she was at a house where bad things happened. She'd been confined there, sexually molested for months on end, and hooked on heroin. So just about that time, she escaped, and we got a call from a hospital somewhere in that area that she was there and that she'd come gather her up. And I rode with them down there, and we picked her up and rescued her the second time.
Mark, what ended up happening with Jessica?
Well, it was there was some stuff in between there. This was happening at the same time. This would have been April of 2014. And Matt had just part of the reason Jessica had gone down, wanted to go down there, is because Matt was dating a girl that she just didn't get along with very well and didn't like her. Matt had married her while she was gone, and built a house and had a nice big wedding and all that stuff. And just about the time that we were going to get Jessica, and he then was looking around for a place to put her in rehab, and this was before the big opiate crisis where there were programs all over the place. It was very difficult to find any place that would take her for more than 7 days or 14 days. So he did find a place, and he got her in there. And, she had a sort of a partial recovery. But, there were other things going on in his life that made it very complicated. After she was in and out of rehab. She went back to school, and got her GED or whatever. But then there was the issue that Matt had in 2017, and Jessica had been in a special rehab program, drug court program, where her record would be cleared, and if she finished the program. And Matt was in jail at the time. I think he had been convicted and was in prison. And I went to pick Jessica up at a friend's house, and I did, and she was telling me, she said, "Grandpa, I just can't do this." She'd had a beer or two or something, and she was really having some serious withdrawal issues. And I said, "Well, Jess, you have to do it. This is just what we got to do. You got to suck it up." She then got a phone call immediately and ran up to her room, and that night I heard her get up at 1 a.m, which she did quite often. She was sleeping in a bedroom about 20 feet from mine. She went down the stairs, get milk or something, came back up, and Kathy found her the next morning at 9:15, dead on the bed, having overdosed on fentanyl, which was a brand new drug at that time. So she passed away while Matt was in prison. But one of the things notable to me, and especially in this context, is that the issues with Jessica back in 2014 were coming at the same time that Matt had discovered his new wife was having an affair with a guy from work. And we have some correspondence, with the other guy's wife. They talked about it and said, here we are, what are we going to do? He ended up divorcing that young lady, and 3 months later is at a canoe trip with Ms. Rogers. And 2 months after that, they've conceived a child. And I don't know how that happens, but I do know how that happens. And that didn't turn out well either.
Is that your grandson, Lachlan?
Yes.
Overall, with Jessica's struggles and the challenges that Matt went through in trying to provide her a secure and safe environment, what effect did that have on Matt overall?
Well, it was constant stress. I mean, I just sat back and watched. I mean, there wasn't much I could do, but again, it was very difficult back then to get treatment, and Jessica was very, very ashamed of what had happened to her, and she was a different person after that. Didn't want to talk about it, didn't want to talk about anything, where she was just happy, bubbly, wonderful girl before she went down there. And he was trying to match insurance. He had a good job and good insurance. He was trying to match insurance with programs, and again, there just weren't very many there. So it's very, very stressful. And then again, other parts of his personal life. And he didn't wear any of that on his sleeve. I mean, the whole divorce thing happened very quickly. I mean, very quickly. There was no fighting. He gave her half the profits of a house that she never put a nickel into. He just wanted to move on.
Tell us about Matt's career and what his skills are professionally.
He's a software developer. I think his specialty is the Perl web programming language, but he works in a whole bunch of different languages. He was going to Western Michigan University for a computer engineering degree, and while doing that, he started a part-time job as a help desk person at Liquid Web, which was a startup. And that company did very well. They now have 500-600 employees, I think, and they're all over the world. But that's where he started, and so he was working and going to school and trying to take care of Jessica. We were helping, of course, but once he built the house in maybe 2010, and they moved in, we didn't see much of Jessica. There wasn't much we could do.
About how long did Matt and Kay know one another?
I think they knew each other in high school. Kay's first husband was a fellow on the wrestling team that was a couple years behind Matt, but they knew each other pretty well. So they've known each other for a long, long time.
You understand why you're here today, Mr. Terry?
I think so.
That the reason why you're testifying is because the jury has found Matt guilty of first-degree murder. In the state of Florida, the mandatory sentence is life in prison. And the sentence that is discretionary upon this jury, these ladies and gentlemen, is whether or not Matt will be sentenced to death. Understand that?
I do.
And you see Matt in the courtroom today. I've asked you some questions that are very personal, and you're sharing this information, this very private information, in front of many people who you've never met. I don't imagine that's easy. But tell us about how your relationship with Matt would continue if he is sentenced to life in prison.
But we do what we can. We do all we can do. We're here. We're still his parents and still good friends, actually.
What do you enjoy about him? What do you enjoy about your son? What do you think about your relationship with him?
Just hanging out, talking about different things, arguing. That's what we do the best.
You love your son?
Of course.
Imagining that you have to come down here on occasion and you have to see him. And you're sitting across from the visitation table. What do you talk about?
What's new? What's up? Those conversations are always difficult because there's always somebody listening in. Not that you're saying anything terrible, but it's a little uncomfortable. One-on-one, we talk about whatever he wants to talk about. I don't think the relationship is based so much on any information you bring or any banter. It's, you're there for the support. People that are incarcerated do much better with support from the outside.
So if I hear you correctly, you're talking about just being in somebody's presence.
Correct.
And it's not so much the words, it's not so much the topic. It's the fact that that person has a presence in your life.
Yep. I grew up in a family with 6 kids, and my dad was always there to help people, and he did. He ended up stepping up and doing things for all the different kids. And he told me late in his life, he says, I never was able to help you with anything. What was there something wrong? And I said, no, Dad. I said, I just was lucky I never needed it, but every day I took risks that were factoring you in the deal. In other words, I felt I knew that he was there when I needed him, and that was part of who I was and how I operated at that time. And that more closely describes, I think, the relationship that people have in this instance.
Do you believe that Matt has that view of you?
I do. Yep.
If I get 1 second. Judge, can we approach?
Yes.
Afternoon, sir.
Afternoon.
You said it, you love your son, as any good father would, right?
Correct?
Okay, and one of the things that you were asked about is you were asked about whether or not your son was loved in general by the family, right?
Correct?
Because family members love their other family members, right?
Correct?
Parents love their children, right?
Correct?
And you were asked about the fact that the defendant had a child who your family unfortunately lost, and I'm sorry for your loss, but the fact is, kids need their parents. That's what you talked about, right? Because Mr. Terry wasn't available for a period of time, his daughter descended into a dark place and ended up in a bad situation, right?
No.
No?
No. It was, she descended into a dark place when she went to visit her mother.
Yeah, that's where it started, but that's not what you said, right? What you said was, Jessica ultimately died after Mr. Terry wasn't around for a little bit, right?
That's correct.
Because there wasn't a parent around to be there for a kid, right? Because kids need their parents. Mr. Terry, we can't agree that kids need their parents?
Objection.
I,
You could ask Mr. Diaz to tone it down a little bit.
Well,
Speak respectfully to the witness.
Well, that's overruled. Just answer the question.
I certainly would agree that kids generally need their parents, but we had acted as Jessica's parents. We had raised her from age 3 to age
And Mr. Terry,
12 or
I want
14.
to applaud you.
Wait, don't interrupt him.
Mr. Terry, I want to applaud you. Okay?
Objection, Your Honor. I think the witness can be allowed to answer Mr. Diaz's question.
I instruct you. If you have anything else that you want to finish, you can finish.
Well, I was just saying that she was not without parents. She was not without parents at that time.
You don't think that if your son had died, unfortunately, it would have impacted your granddaughter to not have her actual father? I'm sure that you and your wife would have loved her. I don't doubt that. You're telling me that the loss of a father wouldn't impact her?
Objection.
Legal basis?
Argumentative.
Overruled. I'll allow it.
I'm saying that the quote-unquote loss, in this case, was more like an absence, and it had been maybe 3 months. The absence of her father for 3 months when she's 19 years old is not going to be the thing that sends her into a tailspin. She had been in a terrible tailspin for 2 or 3 years and was struggling to climb out.
Mr. Terry, let me ask you a question. Your son loves you, right?
Sure.
I assume, and I don't mean to be grim, but at some point you will leave this world. You don't think that your loss to your son is going to be hard for him to deal with,
Objection.
even though he's an adult?
Hold on. Wait.
Objection. This is purely argumentative, and he's mischaracterizing the testimony of the witness.
Overruled. I'll allow.
Mr. Terry, can we just agree that it's hard for kids to lose their parents, whether they're 5 or 50?
Well, it's always hard for kids to lose their parents, but to answer your earlier question, when and if I die, none of my children were raised to go into anything close to a tailspin at my death. They understand how that sort of thing works. Jessica was the same way. She wasn't certainly happy about it, but since she was 16, she had been struggling with all her might to be independent.
All right, and can we agree that your sons won't go into a tailspin, as you just said, because they had a good family and that family loved them, right?
Correct.
And I don't mean to suggest that you gave them the wealth of British royalty, but you gave your sons, and you gave this son in particular, all that you could give him in life, right?
Well, you're always asking yourself that question, but I'll say right.
I get it. I'm a parent, but you've done everything that you reasonably could have done, right?
First time around, sure.
I'm sure he didn't have everything he wanted, but you gave him everything he needed, right?
I think he had enough. Yeah.
And he could go to school, he could get a degree, he could be in the Marines, he could have a job, he could be successful at a job, right?
Correct.
He was healthy physically, mentally,
Correct.
right? He didn't have a hard upbringing, did he?
No.
There's
His upbringing was very good. I think it was what happened after that.
I got it. But I mean, he had all the opportunities and chances that most other people in the world have. I mean, as a general rule.
That's a general rule.
He didn't bear some hardship.
No.
Okay. You said that Kay Baker was close to your family?
Yes.
She wasn't just close to Mr. Terry, she was close to your family?
Yes.
How close?
Which part of the family? She had graduated from high school with my son Peter. She had spent the weekend at our house at least a dozen times in the previous year, and we had seen her quite often during the time of mass incarceration. She coordinated with my wife different things that we would do with them, so very close.
Okay. She was very close. Because I noticed that for all the other women in Mr. Terry's life, you had nothing but negative things to say about them, right? The mother of Jessica was a bad mother.
Objection is on his testimony.
Well, now you get the opportunity to redirect. Witness can finish the question.
I mean, what you said was Jessica's mother was a bad mom, right? She had her in a bad situation. She was exposing her to bad people, right? That's what you said.
I didn't say that she exposed her. I said that her environment, where she had grown up, her
How old was she when you had to rescue her the first time?
3.
3. She was a 3-year-old child, and she was in a bad environment. Who was she living with?
Her mother and her grandmother and her stepsister.
So you're not suggesting that you were bad-mouthing the mother by putting her in a bad situation when a 3-year-old has no control over their life?
Well, the story was told rather quickly, briefly. As I mentioned before, Nikki, the mother's own stepfather, told me directly over the telephone, this is not a good place, meaning the North Carolina, Greenville area where they were. This is not a good place to raise a young girl. She should live up with you.
Right. And in that case, you made this...
Well, that doesn't mean she's got a bad mother. That doesn't mean she's got a bad family. So
What about
I just want to clarify that.
What about the wife that he built the house with? You went out of your way to mention that she had supposedly been unfaithful to him, right? You made sure to mention that?
Well, I mentioned that in the context of this. These were all the things that were happening all at once to Matt. I didn't even know it at the time, to be honest. I knew that we had the issue with Jessica because I drove with him down there and rescued her from the hospital and the sexual molestation, trafficking, and the heroin addiction. That was bad enough, and I didn't, frankly, find out a whole lot about that at the time. It wasn't the thing she was crumpled up in the back seat under a blanket. So, we didn't talk about it that much, but I knew what happened.
Okay. You keep going out of your way to keep spelling out the bad details of every other person surrounding Mr. Terry. Let me ask you a question.
Yeah.
Did you think that Michelle Rogers was a good person in Mr. Terry's life?
She had her moments.
Wait. Legal basis?
Outside the scope.
No.
Did you think Michelle Rogers was a good person in Mr. Terry's life?
I thought that Michelle Rogers was extremely opportunistic in their initial relationship, but she did a lot of really good things. She got Matt running, I think taking better care of himself, doing things other than just going out and partying all the time. However, that relationship then devolved, and it was actually Ms. Rogers that insisted they take the entire day off, March 17th, to do nothing but drink.
Is there somebody in the world you call bitch face?
There's
Who
a
is
lot
it?
of, depending on the context.
Mr. Terry, don't play coy. Is there somebody in the last 24 hours you called bitch face?
There certainly could have been.
You don't remember?
I don't remember specifically saying any one person. I used colorful language.
Let me make it.
Do you have something in
easy for
mind?
you. If you had a phone conversation with your son in the last 24 hours, where he was talking about somebody who testified at his trial, and you called them bitch face.
Objection.
Legal basis?
Approach.
Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid any reports of the case outside of the courtroom. Not sure exactly how long it's going to last, but we'll get you back in here as soon as we can. All rise for the jury.
Can the witness step down out of the box, please?
Yeah, you can step down, Mr. Terry. You'll just stay close. Outside. Outside.
Which way?
That way.
Judge, just, oh, I'm sorry, he's not over.
If you're looking for case law and whether there's an exception, is that what you're looking for?
Yes,
You got me there. I mean, you don't need to present it to me.
certainly.
All right. So the issue right now is the state's failure to disclose content of a telephone call between the defendant and the witness that apparently occurred within the past 24 hours, and the state's intention to get into the content of that phone call for impeachment purposes of the witness. Is that a correct assessment of the current situation?
Yes, Your Honor.
And the defense's complaint, or whatever you want to call it, that constitutes a discovery violation, not disclosing it, and requesting a Richardson hearing to determine what, if anything, should be done, or if in fact it is in fact a violation.
Yes, Your Honor.
And at the bench, we discussed that the state did not know, the state's position was that they did not know that it would become necessary because they did not know what the witness would say. Mr. Diaz, I believe that the law says that if you have it and there's any possibility that it may come up, you need to disclose it before. So do you want to make argument that the failure to disclose it is not in fact a discovery violation?
Your Honor, I don't have any case law to cite at the moment. I didn't come armed with case law for this issue, so I don't have any case law that I can point to, which I know is often the first question Your Honor asks. I don't have anything at the moment to present you that I can say one way or another. Again, I want to make it clear. I did not anticipate that they were going to put Mr. Terry, Sr., the father, on the witness stand to talk bad about the women in Mr. Terry's life, which he did at great length. Right? I don't know why it was necessary for him to say that another girlfriend or wife of the defendant cheated on him. I don't know why they needed to say all of the things about whatever was going on with the daughter, other than to say that, they went and got her. It was not a great situation. Certainly I understand the part that they need to say she died of a heroin overdose. I get that part, but that comes much later. And so this gentleman got on the witness stand and basically tried to badmouth every woman that he mentioned in Mr. Terry's life. And I tried repeatedly to ask him to just admit that that's what he was doing, and he kept hemming and hawing.
I hear you, and I was here, but the issue is not whether it was in the scope of the direct examination or anything, but you were armed with, you were aware of, you had listened to a phone call that you had that information that this witness had made these statements about someone who testified at this trial.
And the defendant knew those statements as well, because the defendant's the other person on the call.
But that does not alleviate the state's obligation to disclose that in discovery at all. So you had that, you knew what he said, you knew he was testifying, you didn't tell them, and then I hear you that you didn't know how he was going to answer your questions, but then when he answered your questions differently than you expected or not completely how you wanted, you questioned him about the call, the statement that he made on the call, disclosing it now in front of the jury and to the witness without having previously disclosed it to the defense. I believe that that is a discovery violation. So the next step is whether it was inadvertent or unintentional. What is your position? Well, let me first hear the defense position on whether it was inadvertent or unintentional.
If I could just correct very quickly.
What do you, wait, let me see what you're correcting me.
No, not correcting you. Correct Mr. Diaz's characterization of Mr. Terry's testimony. He specifically said he wasn't calling Nikki, who was the mother of Jessica, a bad person. He was saying that she was coming from a bad environment, not blaming Nikki at all. He actually said Nikki was not a bad person. He had no issues with Nikki. The only person that he had apparently negative thoughts about was Mr. Terry's first wife. Michelle Rogers never came up in direct examination. I didn't ask him one question about Michelle Rogers. Nothing. I didn't ask him generally how he felt about the women in Mr. Terry's life. I didn't ask him about Kay Baker, to comment on Kay Baker's character. I didn't ask him to comment on Nikki's character. I didn't ask him to comment on Melissa Headley's character. None of it. I didn't ask him to do any of those things.
So
He actually-
is it now becoming a relevant
No.
objection
No,
that I didn't previously
no,
hear?
That was what, if you notice, Mr. Diaz opened his own door by questioning about Michelle Rogers.
Well, you
He
can't
was-
do that.
Wait. He was trying to create the circumstance that would allow him to get into that phone call, that would create the own impeachment value. That's what he was trying to create. We all know that I didn't ask anything about Michelle Rogers. How that is within the scope of direct is beyond me. I didn't get into any of that. I didn't get into whether or not he had a son with Michelle Rogers. I didn't get into the events of March of 2017. Got into none of it. He opened the door by asking about Michelle Rogers. And then, knowing that he had that information about the phone call, decided to use that to characterize Mr. Terry's testimony as overall hostile towards the women in Mr. Terry's life, when that is not even remotely close to what the testimony was. So he was trying to create the admissibility. He hoped and wanted to use that information. This cannot even possibly be inadvertent. It was deliberate because he's creating the circumstances that will allow him to justify asking the question. When we look at it, it's quite obvious now. Why is he asking about Michelle Rogers? I never brought that up. Well, now we know. He wanted to get that phone call in there. I mean, inadvertence, it's obvious he set the stage to ask that question, knowing that he hadn't disclosed that to the defense.
All right, so that's your argument on that it was intentional. Let me hear the response.
No, I would ask if you can, I know it's a difficulty, but I would ask if you can to go back and read the actual way it played out. I gave Mr. Terry at least one, if not two, chances to acknowledge that he doesn't speak kindly of Ms. Rogers before I even got to the word bitch face. Even then, I said, do you call anyone bitch face? He then hemmed and hawed and tells me, oh, I call lots of people bad names. And then I said, do you call Michelle Rogers bitch face? And then again he sort of hemmed and hawed. And then I finally put the point to him. I was hoping, well before I even got to Michelle Rogers, that he would just acknowledge that he doesn't have anything nice to say about the women in Mr. Terry's life.
Judge, that's
But
exactly
the
the point.
decision. Oh, and we're doing one. You pick. You guys can
No,
pick who's.
I'll defer to Ms. Perry at this
All right,
point.
then you're not saying anything else. I don't usually do this, but it's only one on the remainder of this issue. So it's you,
That's
Ms.
fine.
Perry. Mr. Diaz, your response to why you didn't disclose it previously to the defense prior to questioning the witness, as whether that's intentional or inadvertent, is that what?
Your Honor, I legitimately expected they were going to call Mr. Terry, the father, to talk about he loves his son, he's a good son, he's well behaved, we've had a family, we've suffered some tragedy, we've lost a grandchild, things of those nature.
Why didn't you disclose it after the direct examination if you thought that the direct examination opened this door?
Because I sincerely hoped that he was just going to acknowledge the two women he talked about. He at least would say he didn't have nice things to say about it. But even that was a struggle. Even that was not an easy thing. He just wouldn't even concede that. I mean, I don't want to characterize Mr. Mark Terry with a broad paintbrush, but like, it's clear that I would ask him what I think are some fairly easy to agree with questions, and he wouldn't even meet me halfway. Like, I was trying to get him just to concede a point, and he would not.
So is your argument that
I did not
you didn't disclose it because you didn't intend to use it?
I did not intend to use it.
All right, let me hear the response.
Judge, his answer shows that it was willful. He can't say, oh, well, I didn't know that the witness might not admit to something I knew about. The question is, did he have information that he failed to disclose? He intentionally failed to disclose it, not just last night when he got the information, but again during direct examination when he decided he was going to go down this route. He didn't even bother to come to the bench and say, you know what, I inadvertently didn't disclose something. He intentionally kept it to himself so that he could use it in cross-examination, which is a willful violation.
Okay, whether it's willful or inadvertent, which I'll ultimately make a decision on, tell me the defense position on whether it's trivial or substantial.
It is substantial. It completely changes what we would have asked Mr. Terry. We would have maybe not even put him on. If we knew that, I'm sorry. If we had known about this, we may have called Kathy Terry instead, the mother, where there was no issue. They kept it quiet so that they could get us to put him on the stand, willfully choosing not to disclose it, and then intentionally ambushed us with information that they knew that they had and chose not to give. That is the exact definition of a substantial violation. We would have completely changed whether, one, we would have even called him, and two, if we had chosen to call him, the manner in which we would have directed him.
All right, and so the third part of that test is what the prejudicial effect on the trial prep was. It sounds like you've combined those two tests together in that's what made it substantial, the fact that it was prejudicial.
Yes, Your Honor. Substantial first because the information is such that it is very clearly the type of evidence that perhaps would change our entire strategy with that potential witness. But the prejudice part goes to the fact that this occurred all in front of the jury. The jury has now heard a witness who perhaps we never would have even called, a witness who, if we had chosen to call, we would have went down a different road with and perhaps not even talked about any of the relationship type issues that came up during the direct, and perhaps wouldn't have even had a cross-examination of, because depending what we went down the road of, Mr. Diaz has indicated he may not have even asked those kind of questions. So we've been substantially prejudiced. This is one of the main witnesses for our penalty phase, the father of the defendant, who we may have chosen to substitute the mother for and couldn't make that decision because of their intentional violation.
All right, but let me also point out at this time that what the lawyers say in their questions is not evidence. The evidence comes from the witness stand and the witness. My recollection is that the objection was made before the witness was able to acknowledge, in fact, he was ultimately denying that he called somebody that name recently.
But Mr. Diaz, in his question, put the information in front of the jury, and you can't unring that bell. You can't unring that bell.
Well, we'll agree to disagree on that.
Judge, he repeatedly asked it. He specifically indicated it was within the last 24 hours. They can't just disregard that.
Well, I mean, as to repeatedly asking, the first time that it was evident, you all were on your feet objecting. So, I mean, I don't know how many times you let it go before you jumped up and objected, but I think as soon as it was clear there was an objection, and my recollection is that the witness didn't even get a chance to ultimately confirm or deny the phone call or the calling someone the name on a recent phone call. If I'm going to rely on my recollection of the record, I do believe that it can be cured with an instruction to the jury. I will find that under the... Is there anything else you want to say?
Judge, if I can be heard, I know you
No.
want...
Sorry.
Just one-
Sorry. No, sorry.
If I could have a moment, then.
You can have a moment.
Judge, just for...
Well, in a minute. In a minute. Go ahead.
Judge, I would just point out that the reason this can't be cured with a curative instruction is because it is a misogynistic comment that was made by the father between him and his son, the defendant, who's facing death, in regard to one of the witnesses who actually testified and who they based their conviction
Let's
on.
be clear, though. There's been no suggestion that Mr. Matthew Terry made this comment.
It doesn't matter. It's imputed to him in the way that they have brought this information out.
How is it imputed when they specifically asked him whether he made the comment?
Because it's in the course of a conversation between the two of them. The jury isn't going to punish Mark
So if I
Terry.
say
They're gonna
something
punish
bad
Matthew.
while you and I are talking, that's imputed to you, and you suffer the consequences of what I said that was bad?
If you're my father and I'm having this active discussion with you about somebody you're calling bitch face and I'm not telling you, no, that's not true, absolutely. And he's the one they're going to sentence to death based on.
And we don't have a conversation.
And it was on the very day she testified.
Well, the phone call?
Yes.
No, none of that has come out. I mean, that's, you know, we're far exceeding the testimony at this point.
We're not, because that's the way they predicated their question.
All right.
Mr. Diaz intentionally put all that information into his question.
All right. Well, I certainly respect your position. Mr. Diaz, did you want to say anything else?
No, thank you.
All right. I am going to find that the failure to disclose was in fact willful. I'm going to find that under the totality of the circumstances, including the fact that the witness never really answered, acquiesced, or conceded the statement, that it is trivial. I am going to find that it does have some prejudicial effect. Now, the degree of that prejudicial effect obviously can and may be argued at some later point. I'm finding that it has a prejudicial effect, but the prejudicial effect that I believe it has can be cured with an instruction. I'm going to offer you the opportunity to construct whatever instruction that you want without waiving any objection. If you decline to construct your own instruction, the court will design its own instruction to disregard. And let me just say, I'm speaking out loud here, but I understand that sometimes an instruction can make things worse, and why defense may, not want to ring the bell again, so to speak. So there is the possibility of being specific, or there's the possibility of simply saying, members of the jury, I instruct you to disregard the last interaction between the Mr. Diaz and the witness as a simple instruction. But at the very least, it is a instruction to them to disregard. I obviously will preclude any argument whatsoever. I will instruct Mr. Diaz to move on to another topic.
Judge, there's nothing that can carry it. We have no language to carry
Okay, then I'm simply going to tell him to disregard the last
I've
interaction.
also moved for a mistrial,
I'm denying the mistrial.
and I'm asking for prosecutorial sanctions.
Well, I'll reserve on prosecutorial sanctions for the willful violation.
Thank
We're
you.
going to bring the witness back in. We're going to bring the jury in, and I will instruct them to disregard. And I've already instructed Mr. Diaz to move on.
And,
Is this on the
just for
same topic?
No, for access to the record, please. Had Mr. Diaz disclosed this information, I would not have called that witness. We have other witnesses that we could have called to get the information that I had from Mr. Terry. Secondly, when Mr. Diaz knew that he was going to bring this up, he chose intentionally not to approach the bench so that
Okay,
this
I've already
court...
made
I know.
findings that it was willful.
I understand. So that this court could properly move on the admissibility or rule on the admissibility of that statement, and that we could be heard in response to
I
its
hear you.
admissibility.
I hear you. But it's all water under the bridge now. I've resolved this issue, and we're moving on.
Judge, the witness, I would like to instruct not to talk about this at all when he comes in, but I don't want to do that because he's on the stand and I'd be discussing
Not a
his
problem.
testimony.
You're requesting that I instruct him not to talk about it.
That
We'll
would
bring
be-
him in first. If we can get Mr. Terry, put him back on the stand, I'll instruct him. We will bring the jury in. I'll instruct the jury. We'll keep moving. That was their afternoon break.
Judge, I don't have any other questions for this witness, so he's not going to answer any more questions for me. I don't imagine the defense is
You
gonna
want to
have-
redirect him, though?
I have no idea. I'd have to talk to counsel about that. And also, we would appreciate if the state would provide a copy of that recording before we proceed on any questioning of Mr. Terry. We don't know if we're going to try to repair it. We don't know what else was said. We don't know
Whoa,
the context. We would like to have the benefit of what Mr. Diaz listened to so that we can properly move further
And anything else he says.
and anything else that he hasn't disclosed. We have no idea at this point.
Well, he doesn't have to. Anything that he may use, if he tries to use something he hasn't disclosed, then obviously.
It's a discovery violation. He's brought that out in front of the witness. We would like the benefit of the complete conversation, please, so that I can determine whether or not I need to further question this witness and repair whatever impressions the jury may have of him. And I also like the opportunity, if you don't mind, to speak to the witness to find out what else was said.
Judge, I will happily give the defense a copy of the recording. I want to be clear, I do not have a copy of the recording. I did not come here intending to use the conversation, so I don't have it on a disc. I will still happily give them a copy, but I don't have it on a disc at the moment to hand to them, so I will comply with whatever Your Honor decides, but I just want you to understand, I cannot do this at this instant.
So let me ask the defense. I mean, we can either break for the day, which I'm not at all in favor of, or we can move on to the next witness. You can get the copy of whatever they have. Mr. Terry, I suspect is, or well, anyway, was not going to be released, but can be available. And if you want to recall him, I will still instruct them. And then if you want to recall him for redirect, I will allow that after you've had the opportunity to review the transcript of the phone call. And any other things that you want to discuss, I will allow you to discuss the phone call with him.
And that's another issue that we have, obviously, is puts us in the precarious position where we have to figure out the best course for Mr. Terry, whether or not to continue to pursue that line of questioning, to repair the impressions that have been left with the jury.
And I'll give you as much time as you need for that. My question is, do you want...
I don't know. I would, I agree, we can move on with the next witness, and we can just keep Mr. Terry under oath for now.
That's exactly what I want to do. What I'm going to do is, though, I'm going to instruct them when they come in to disregard the last interaction between Mr. Diaz and Mr. Terry. Mr. Terry will no longer be on the stand. However, he is subject to recall for your, not continued redirect, but for your redirect, however you wish to proceed with it.
And also, we would like that recording at some point made a court exhibit.
Absolutely, absolutely. That'll be number 5. Mr. Diaz, as soon as we finish today, or if you can instruct someone, Ms. Ismer, if you can be on getting a disc or whatever you use these days. If they're not discs, they're whatever. If you just email it, but please get it to the defense ASAP.
And if there's anything else that Mr. Diaz has listened to that he says now he doesn't intend to use, but obviously what he intends to use does not determine what he actually uses. So if he could make it clear right now what else he has listened to or has been privy to in terms of any conversations our witnesses have had or any conversations Mr. Terry has had that he's in possession of or has listened to that he does not intend to use. If we could have that on the record, please.
Mr. Diaz, is there anything else?
What do you mean, anything else?
So that means
I don't have a single recording, to be clear. I've not downloaded anything. I don't have anything on a disc in my possession. The defendant got found guilty yesterday. I went to listen to his jail phone call to see how he reacted. That's where I heard the comment.
Are there others that he heard? Because the standard isn't what he thinks he has to disclose. He has to disclose anything that has any potential for being used. So if there is anything else, if he listened to any other calls, he doesn't get to decide when he discloses them. He has to disclose them.
But I don't know that they're required to provide every phone call that they listen to.
Yes, they are. If there is any reasonable basis to believe they could possibly need to use it, they have to give it.
Judge, I'm willing to agree that I will not reference any other phone call that I've ever listened to. I know that I listened to phone calls when the defendant was first arrested and he was booked into the jail, the sort of initial phone calls when he's first. I certainly know that. I know that I've listened to phone calls here and there in the interim. I do not know every single phone call that I've listed. I don't intend on using any other phone call. I will just forego. If the defendant fully confessed in a phone call somewhere, not that he did, but if he did,
Well, that stage is over.
I understand. I will just forego whatever there is in any phone call that exists as of 8 a.m. this morning.
Well, he has disavowed any intent to use it. Therefore, he's not required to disclose it. He cannot use it, period.
And to be
As
clear,
long as,
I'm not...
as long as you're ordering, he cannot use it.
He cannot use it, period.
Okay. And to be clear, nothing I've heard was exculpatory or any of that. So.
Appreciate that. All right. So, I'm going to bring the jury in. I'm going to instruct them. I'm going to ask you to call your next witness. Let's get the jury. Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. I hope you enjoyed the break. That will count as your afternoon break. So I do not expect to give you another break unless we go late. I do not know as I sit here right now if we will go late, and if so, how late we will go. But I promise you if we go past 5, I will give you another break. But at this time, I do have one brief instruction for you, and that is I am instructing you to disregard the last interaction between Mr. Diaz and the witness who was on the stand, Mr. Mark Terry, including the last question and any answer, if any answer was provided between the state and the witness. I'm going to ask the defense to now call their next witness, and in fact, Mr. Kane has stepped outside to retrieve the next witness. Ruby Williams. Miss Williams, good afternoon and welcome.
Hi, how are you?
I'm good. If you'll face me and raise your right hand, I'm going to swear you in as a witness.
Okay.
Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you, ma'am. If you'll follow the bailiff now, please watch your step. That's a ramp there, so be careful. And then when you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. You let me know when you're ready, and then I'm going to allow the attorneys an opportunity to ask you some questions, ma'am.
Okay.
You're going to need to get closer to the microphone. Sorry about that.
Can you hear me?
Yes, I can. We'll let you know if we need to speak up or get closer.
Okay.
Mr. Kane, you may proceed.
Thank you, sir. Morning, Ms. Williams. Or actually, good afternoon.
Good afternoon.
Can you identify yourself, please?
Ruby Williams,
Where are you from?
East Lansing, Michigan.
Okay. Ms. Williams, have you and I met?
Yes, once
Okay. Where was that?
at Terry's home in East Lansing, Michigan.
And that was what? Last month?
Oh God, I didn't keep track.
It's been a little bit.
Yeah, it's been a while. 2-3 weeks. 3.
Yeah. How well do you know the Terrys?
We have known, let's see, my oldest just turned 50, and I think we moved to Duran in East Lansing when Benji was 10, so it's been over 40 years.
Okay.
Yeah.
Can we inquire and make sure everybody can hear Ms. Williams okay?
Is everybody able to hear the witness? Speak up a
Louder?
little bit louder. Okay, I'm going to need you to get a little closer and speak up a little louder. They're having a little difficulty in the back.
Okay. Is it okay? Okay.
And don't hesitate. Don't be shy, members of the jury. If you can't hear, raise your hand. Let me know, and I'll turn it up.
So about how long have you known the Terry family? About how long? How many years?
Oh gosh. Christopher was 2.
Your son
So-
Christopher was 2?
Yeah. 2 boys I have, and Christopher was 18 months, 2 years old, I'll say. And we've known the Terrys, gosh, well over 25 years. 30, yeah. It's been a long time.
And what is your husband's name?
Benjamin Williams,
How long have you and Ben been married?
53 years.
Okay. About as long as the Terrys have been married, right? Just about?
I think they've been married 48 or 49 years.
And what part of Michigan were you all living in where you got to know each other or first became acquainted? Where was that? Was that in East Lansing?
That's in East Lansing, home of the MSU.
Spartans?
Yes, Spartans.
And just right outside the campus of Michigan State University, right?
Yes,
Very close.
yeah.
And do you know Matthew Terry?
Yes, I know Matt.
Okay. Can you point him out for us?
There he is. Oh, this is hard.
How long have you known Matt?
Gosh. Well, I'll just go see it. Benji is 50. Matt is maybe 4 years younger. So over 30 years.
Long time.
Oh, yeah.
But let's try to put it in perspective a little bit about how old was Matt when you and Ben first became aware of him as a little boy. How old was
Gosh.
Matt?
I'm probably not going to say the exact age because I'm in my 70s. And
You don't look it.
thank you. But probably if Christopher was 2, then Bet was either 4 or 5. So since he was 5 years old, I would say. Because when
No, go ahead.
when we met Matthew, we were in our home. We had been there not very long, and this child. We were sitting at the table having breakfast, and this child walks in with this big smile on his face, and it was Matt, and that's how we met. That's how we met him. He introduced himself first, and then we met the family. Well, you want me to shut up? And then we met. We were sitting in the backyard, and then we met Mark, who came over to get some assistance from Benjamin. Mark was putting in a picture window. Because we hadn't met him at the time. We met Matt, but not Mark. And then that's how we know the Terry family. They live a house before ours. So.
Yeah, and Matt's going to be 48 in January.
Yeah, because my oldest is 50. Yes.
Okay. So when Matt walked into your home, about how old was he?
Gosh, let's see. So if there's 2, so Matt had to have been 4 or 5.
All right, so he's a 4 or 5 year old kid, just kind of walking into your home and with a big smile on his face and just happy to be there.
Well, yes, because it was that kind of neighborhood, and also I suspect that he had probably seen the boys, and he was probably happy that there were boys in the neighborhood, because across the street were only girls. So, and then he had his brother, so new blood, so to speak. Yes.
And can you share with us, some of your thoughts about Matt when he was that age, and what his curiosities may have been, and how he expressed himself? Can you share with us some of those occasions?
Gosh. My first impression of Matt when I met him was he had the brightest eyes and the biggest smile. And when he walked into the house, it was like he had known us all the time. And we're sitting there at awe when this kid is just jabbering, talking. He was inquisitive. He asked questions, I remember, and he may have even sat down and had a second breakfast with us. He probably had breakfast, but he was just a joyful kid. He was a child. The children wanted to go out and play with him because there he was, but he was just a child full of life and joy.
And over the years, how did your relationship with the Terry family develop, and how did it flourish, and with your families and spending time together, and how well you got to know Matt? If you could talk to us a little bit about that, and what kind of qualities you saw in him as he got older.
Oh. Well, they're growing up, the boys, their interest in, go back up. There's this lady, Matt's grandmother, Grandma Lil, she's passed away. And she used to do things with them, and because there were 4 boys, she would take them one at a time to a Michigan State basketball game, Benji being the first because he was the oldest, and then Matt being second. But the family, we got to know the grandparents, and of course Kathy and Mark, and Jamie and Lori, Kathy's sisters. They all lived in East Lansing, and we were new to East Lansing, except Benjamin went to Michigan State University. That's where he got his degrees. And we were like instant friends. There was never, they were always there. And it was a good neighborhood. It was good people. We talked, we laughed, we celebrated at times, some holidays, maybe they would celebrate something in their backyard, and the boys would come to our house, and I was the Kool-Aid mom and the popsicle mom. And I do remember Matt would knock on the door and he would say, ask me if it was popsicle time. And Dad would give the treats to the boys, and they would play in the backyard. It was a good time. It was a happy time. They were good kids. I don't remember them. I honestly don't remember them ever fighting. Benji, being the oldest, was probably the boss, but they were all good boys. They were all cheerful and happy.
Did you remain close over the years? I mean, even after they might have moved away to either Detroit or Holton, did you guys stay close and stay in contact with each other, either go to the lake?
We went to the lake, but when they moved out of off of Durand Street, which is where we used to live, on Durand Street in East Lansing, you kind of, because everybody's working and doing things in their life, because they're not there in the neighborhood anymore, it isn't as easy, but yet they were there. Just because you have a friend and that friend moves away, you don't stop having that person as a friend. We didn't talk daily like the way we used to, but when they would come to visit Grandma Lil, maybe they would stop by, or we would find out that they were in town and we would go to Grandma Lil's house, because more than likely that's where they were. And it was, we were still friends. We kept that friendship even today.
Why is it that you guys were so close?
I asked that question because we had something in common. We had our children. We were, it was just that kind of friendship, that kind of life. We were friends. Why are you friends with anyone? Because we liked each other. We even went out to, there was a second family, the Sumlers, and the three couples went out to dinner at an Asian restaurant, and we had fun there. We laughed and we talked about the kids, and because when you're married and you have children, that's what you talk about. You talk about your children. And we were friends because we probably had the same thing in common. Sometimes Mark and I would, Mark teased me a lot, so I tease him. So.
As Matt got older, how did you view him? Did you view him as a good person?
View him as a person?
Good person.
Oh, yes.
And what is it about him that you observed, or maybe an experience, that allowed you to believe or conclude that this was a good person that you knew, or this was a good man who you had met as a very young child? And what are some of the qualities that you observed in him that allowed you to believe that, or to have that confidence that Matt is a good person?
He had some of the same characteristics. They moved away. When they moved away and they came back, I remember correctly, it was different because he was older. Benji and Matt have, 4 years difference there? So Benji's now a teenager, and he probably put up with the boys, but Luke and Christopher are the same age. How do I explain this? Matt had always been a good person, and when he moves away, he comes back. He was different. He wasn't as joyful, but we thought it was because he's older now and he's a teenager or getting close to being a teenager, and he was just. And when you're younger, I think because you haven't been out there in the world, or this little mold where you're growing, this is your world, and then you spread out, and you go around other people, so you're kind of being, and I'm sure with other children being tested, or is that too strong of a word? Because you were raised this way, now you're coming in contact with children who were raised differently. And so you expect some kind of change. You expect an influence from this side, and not necessarily. I'm not explaining myself very well.
Well, did you believe that Matt was a generous person?
Matt was very generous. He was a generous. Matt was generous in that when he got older and his interest was computers, he would, when I would call him, he would to come and fix my computers because I did something every single time, and I was not and still am not computer literate the way some people are, and Matt was my source of person to go to fix things, and he never complained. He would just come. He was. I called and he came. He was there. They were family. They are family.
When's the last time you spoke to Matt?
Last time I spoke to Matt was the Christmas party. Maggie and Luke gave a Christmas party, and I hadn't seen Peter or Matt in a while. And Matt introduced us to his girlfriend at the time, and it was a Christmas party, and I don't remember the year. But it was a celebration of Christmas. That was the last time, and he was different.
Did you know Jessica?
I knew Jessica, but I wasn't close to Jessica because she would be with her grandparents' house, and then she would be at her mother's house, and I wasn't as close to Jessica as I was to her father.
Were you aware of some of the struggles that Matt went through with Jessica? Were you?
No, because Kathy didn't share that with me. She didn't share that part of her life with Jessica. I remember Jessica talking to me, and I was getting dressed. She came over for some reason, and I remember her saying, I was going to church, going to Mass, and she said, "Oh, isn't that like a cult?" I said, "No, that's not a cult." And in the back of my mind, I thought I should invite her to go to church with me, but I didn't. For some reason, I didn't do it. And I wished I had, but I didn't.
You had described the Terry family as part of your family, right? And
they were like family, yes.
And how did you view Matt? If you view the Terrys as part of your family or very much like family, how would you view Matt in that equation?
Well, when they were growing up, he was just like one of my sons. But as I said, when they grew up, Mark, I don't know if Mark got a new job or whatever, and they moved. They were getting ready to move away, and I was sad, of course, because they were the family that we befriended in the neighborhood, or befriended us, and when they moved, it wasn't easy, but you get through it, change, and eventually we moved out of the neighborhood. We purchased our first home, but we still had communication. It wasn't a daily thing, but every once in a while we would hear something, and we still talked. And of course, Christopher and Luke were very, very tight, and we would hear from sometime with Christopher would tell us what was going on. But you know how that is if you have teenagers. They don't tell you everything. They don't share everything with you. So,
now, you understand why we're here today, Ruby?
yes, I do. I understand.
And so the reason why you're testifying is because this jury has found Matt guilty of first-degree murder.
Yes.
Okay. And the minimum sentence that he can get is life in prison without the possibility of parole.
Yes.
Okay. And you're testifying today because this jury has to decide whether or not Matt is going to be executed.
Yes.
And the reason why I'm asking you these questions is because we want the jury to have as much information as they can in order to make the most informed decision about which one it's going to be. And so, you and I have spoken, and we've talked about a lot of things, and we've covered a lot of topics. But if there is anything that you know or recognize about Matt or remember about him that is important to you, then I can promise you it's going to be important to this jury. And so, is there anything about Matt that you absolutely love, a quality that you see in him that is just so valuable and worth preserving that you would like to share with this jury?
I told you how Matt was when we met him. He was growing up. He was kind. He was sharing. He was a busybody. He answered questions. He was the kid that you would have wanted your child to have as a friend. And then he grew up and he went away. And I don't know what happened. I don't. And the very first time when we heard that he had gotten into trouble, it was explained to me what he had done, and I found it hard to believe, but he did it. He did it. And when I would write, I wrote to him in prison, and Kathy's friend, Kathy Rogers, mentioned that she had sent him a book, and I thought, well, I'll send him something too. And I sent him packages of flower seeds. I didn't know that you couldn't send flower seeds. I thought, well, this he can plant it, he can share, because Kathy would say that Matt was helping some of the prisoners with the computers, or he was teaching them. And I thought, well, he could give them flower seeds, and they could plant the flowers, and they would grow, and they would see some beauty in the prison yard, right? But I never heard anything, and I was told, well, you're not supposed to send flower seeds to Ruby. They probably think it was drugs or something. They were flower seeds. But the person that I knew would never had done the first act and this awful thing that he did, he never would have done that, but he did it. He did it. And I don't think that, well, I know that he is not the child, the person that I knew, because he would not have taken a life. And he did. I think that something happened, I think that something happened from the time that we lost with each other to when he returned, because that light was gone out of his eye. But he was a little bit there, because he would call when I would call to have him fix the computer. He did it, and I never sensed anything. I spoke with my priest, because I actually started feeling guilty that I didn't confront him and insist on what had happened to him, because that light that he had grown up with around me was gone, and I didn't know. You didn't share. You didn't tell us what was happening. You still haven't told us what was happening in his life. And then he went to the Marines, and God only knows what happened there. My brother was a Marine, and he came back kind of strange.
Legal basis. Speculation, and maybe Mr. Payne could ask a question.
Ask another question. Follow up.
And Ruby, what are even throughout, the changes or the fading lights, what were the qualities that endured? There was a goodness?
It was a giving.
There was a goodness.
Yeah.
There was a goodness, there was a generosity. Generosity with his time and his talents and his affections. He was there.
Objection, Your Honor. Leading.
Sustain, don't lead. Rephrase.
Right?
Hold on, ma'am. Rephrase the question.
Okay. Those qualities were there?
Objections.
Sustain.
Leading.
Rephrase. Don't rely on the leading question. Ask a different question. Rephrase it.
Well, tell me what qualities? What qualities? That it doesn't matter where he is. What qualities were there? What qualities did he possess?
The qualities that I appreciated is that he was never rude to me. He was never a person that I would not want in my life or around my children or my grandchildren. And for me, that says a lot, because I don't let everyone come into our space. He was a good person. He came from, I think, good people. Grandma Lil and Grandpa Randy, Kathy, Mark, Jamie, Lori, their family.
And you said that you and Ben have always been very careful about the people you let into your lives.
Because you're raising children. You're raising children, and you want them. I'm raising 2 boys. We are raising 2 boys, and we want them to see quality versus quantity.
And you had you never had any hesitation about letting Matt into your life.
No, of course not. If he were there, he came over, whether he was invited or not. We allowed him to stay. He was a good person. He did wrong. You know that, right? And I'm not saying, if I may, I'm not saying that he shouldn't be put away, because this is not the person that grew up around me or my kids, or the person that I know would never have done this act, who never had done those acts. A person that I know would gave us his time, and that says a lot for a young man because they're busy. But you took a life, and it was wrong. You broke the fifth commandment, but I don't think that you should take his life, because
Objection, Your Honor. Opinion.
I'll sustain. Ask another question.
1 second, Ruby, okay? 1 second.
Mr. Diaz?
Hi, Ms. Williams.
hello,
How was the trip from up north?
long,
Is the weather a little better down here at least?
yes.
Okay. Look, I know that this is all confusing and probably new to you, so forgive me. I just want to ask you some questions, okay? You keep talking about, you keep using past tense words. You keep saying he was a good person. This is not the person he was. Do you understand what I'm saying?
I know what you're saying.
Okay. And so I just really want to hone in on that, because what you started talking about was you started talking about the defendant as a little boy, like before he's even a teenager, before he moved away. He was a good kid, right?
Yes,
But that's when he's a boy. Is that fair to say?
that's fair.
Okay. And then you talk about something changed. The light in him went out. There was a darkness. That's what you talk about, right?
The light in him went out, and there was a difference.
And when you're talking about that period, you're talking about when he's 12 or 13, correct?
He was a teenager,
Right.
junior high.
But, I mean, we can agree we don't send teenagers, well, I guess they're 18 and 19, but as a general rule, we don't send 12 or 13 or 14-year-olds off to the Marines. So what you're talking about is before he went to the Marines, right?
Yes,
You're not suggesting that the light went out of him because he went and became a Marine and he saw something in war, right? You're talking about the light was already gone before he even became a Marine, right?
yes,
And isn't it fair to say that when you heard the first story about the event that happened in Lansing and all of that, initially you thought, no, that can't be true. That's not who Matt is.
that is true.
But you don't think that anymore, right?
He did.
I mean, you said it. He did it.
He did it.
Who you thought he was is not who he was, at least as of 2017, for sure, right?
He was who he was in relation to me or
Right.
my family,
Right.
but
You saw a
he-
piece of him that was just who he was to
Your
you.
Honor, if you could allow the witness to answer his question.
Well, no, I think she finished. Ma'am, did you have anything else to say to that last question?
I was just going to say he was who he was when he was relating to my family or in my world at that time. But then, just I'm sure you've changed from childhood to manhood.
Certainly.
You're-
We all change as we grow.
Yes, right.
I'm not going to debate with you whether or not that's true, because we all know that's true. All I'm just trying to say is who he is to you may be the same, but who he was from a child to a teenager to a man, you realize is not the same person throughout all of this.
Right. He changed. He's different. Yes.
Okay. And so the last time that you really had an interaction with the defendant was somewhere around Christmas of 2016, because when you talk about the Christmas party and meeting the woman that he's with, that's the woman he ultimately has a baby with, a baby called Lachlan, right?
Yes.
So that's Michelle Rogers. Does that sound right?
I didn't, I met her once, but, yeah, right.
What I'm just trying to say is, the last time you had interaction with the defendant was before he even got arrested in Lansing.
Yes.
You haven't had any interaction with the defendant basically in 5 years.
No.
And he moved away for a little while. He was a kid, and then he was a teenager, and in that time he changed pretty significantly, is what you're telling us, right?
Yes.
And you said that, you know, he was close to you, he was close to your family, and so on. But in terms of describing who he is now, didn't you say that you wouldn't let him around your own kids?
No, not the way not with the things that he's done. He knows this.
Right.
He took a life.
I understand.
And I think whatever happened to, if you want me to, whatever happened to him, he didn't share it.
I understand, ma'am, and please understand, I'm not going to ask you to guess or speculate what
Right.
happened. You're not a mind reader.
Right.
Okay, I respect that. I'm just trying to clarify, whoever he was, the person who he is now, in your mind, is a person you wouldn't even let around your own kids.
That's true.
Thank you, ma'am.
Redirect.
Yes.
Matt was born in 1975, and the incident with Michelle Rogers happened in 2017. Can we agree that that's 42 years?
Yes.
Okay. And when, in 2016, he would have been 41, that means that for 41 years, you knew Matt for anything that ever happened that would cause you concern. Is that right?
Right.
Okay. So for those, and obviously in 2016, Matt was still a part of your life, and Michelle Rogers was there, right?
Matt, when Michelle, we didn't know Michelle. We met her at the Christmas party that one time, and so to say that she wasn't really in our lives.
Right, and I'm talking about Matt, that Matt was in your life.
Right.
And there had nothing, you had observed nothing in Matt for the first 41 years of his life, since he was 5 years old or 4 years old. Did you observe anything in that time that ever caused you concern about him being around you, your family, or your children?
No. If I felt anything, I would have spoken to Kathy.
And so the events that are changing the way you, well, I'll just ask you, before any of that happened, you looked at Matt, you thought of him as Matt, right?
Yeah.
Right? That never changed, did it?
No.
No, even when you say that you know, he may have been, you know, may have come back from Holton or come back from Detroit a little bit different, you never viewed him as anyone other than the person that you knew and loved.
No, because children grow up. They become teenagers. They don't talk to you anymore. And when they do, it's probably a chore. But it's.
And Ruby, you've looked at him a number of times during your testimony. You've looked at him. What do you feel when you look at him?
Objection on relevance.
Sustained.
What is it that you still love him?
Oh yes, I still love him, but I feel sad.
Right. So even though you recognize him as somebody who has done something terrible, and that you may revisit whether or not it's appropriate for him to be around your kids, you love him.
Yeah.
That's
You don't-
never going to change.
You don't stop. It's like you don't stop loving
Your child?
your child. Yeah. You don't like what they did. You pray for them. At least I do. But you don't want. I don't want him dead. I think that he should.
Objection on our opinion.
Sustained.
Ruby, thank you.
Released by the defense? Released as a witness?
Yes, that's fine.
All right, and state no objection to being released?
I don't have any objection to releasing this one.
And you may step down, you may be released as a witness at this time. Thank you. Watch your step.
What does that mean? Can I go home?
Yes, it does. You are released.
Okay.
You can go home. Have a safe trip.
I didn't like this.
I'm sorry. I'll ask the defense to please call your next witness.
Thanks. Defense call Benjamin Williams.
Mr. Williams, good afternoon and welcome, sir. I need to swear you in as a witness. Please watch your step. If you'll raise your right hand, please. Thank you very much. Do you swear affirmative testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. If you'll follow the bailiff down to the ramp that leads up to the witness stand, and again, watch your step. There is an elevated ramp there. When you get to that chair, go ahead, have a seat, make yourself comfortable. The microphone in front of you is fully adjustable. Unfortunately, you got to get up pretty close to it for it to amplify your voice. All right, you may proceed.
Thank you. Good afternoon, Mr. Williams. And can you identify yourself, please, and speak clearly in the microphone?
Benjamin Carlton Williams.
And I believe we just heard from Mrs. Williams. Is that your wife?
Yes.
Okay. How long have you all been married?
52 years.
And I believe we heard that you and Miss Williams live in East Lansing, Michigan.
Yes.
Okay. And I'm going to ask you some very similar questions. And you know the Terry family.
Yes.
And how long have you guys known each other?
Almost 44 years, I think, total.
And obviously, Matt is 47, so you've known the Terrys since before they had children? Or actually, when Matt was 3, I'm sorry. When Matt was about 3.
His brother Luke was 2. I don't think Peter had been born.
Okay, so Matt was just a little boy at the time that you guys met the Terrys.
Yes.
And can you tell us about the occasions or about your introduction to Matt and how he came to introduce himself to you guys?
Yes. Actually, Matt, first time I really remember Matt is we lived in a duplex and our bedrooms were upstairs. And I heard a TV going on downstairs. It's like a Saturday, cartoon Saturday. And I remember cartoons being played. When I looked downstairs, Matt was sitting there in front of the TV, his legs crossed, looking at TV. When he saw me, he basically asked me when Benji was going to wake up so he can play with him and look at TV. And Benji's my oldest son. I just looked at Matt and just said, you know, he'll be down soon. And I just turned and went back into the bedroom. And that was a frequent activity that we would hear the TV on the weekend, and we knew it was Matt. And he was just that kind of kid. I mean, very outgoing and energetic and gregarious. He was a great kid.
Mr. Williams, tell us a little bit of something about yourself and what you do for a living.
I work for the state of Michigan. So the department called the Bureau of Licensing and Regulatory Affairs. And I work with a small audit unit that review continuing education for licensed professionals.
Over the years, obviously the Terrys have sort of moved away sometimes and come back, and it seems like, and now everybody's back in East Lansing, is that right?
Correct.
Tell us about your impressions of Matt over the years, when obviously you've shared your first experience with him, or one of your first experiences, and how he came to be more or less a part of your family, but the way you and the Terrys have interacted over the years, and how you've grown in your knowledge and understanding and appreciation of who Matt is.
Again, Matt was very outgoing as a youngster. He just had the look of life in his eyes back then. I mean, he was just very inquisitive, asked a bunch of questions, and in my mind, he sort of reminded me of like a Dennis the Menace kind of kid. I mean, he was just into everything, and you couldn't get mad at the kid. I mean, no matter what he did, he always had this look in his face and his eyes that was just outstanding. And one of the real first instances I recall Matt is in '78. My youngest son, Chris, was going on 2 years, born in '76, bicentennial baby. And my wife was breastfeeding, and Matt was there just looking at her and breastfeeding.
He was 3?
Yeah, Matt was about 3, and 78. And he was watching my wife breastfeed, and he was just looking. I knew he was going to ask something. And he looked at her and just said, "Is that chocolate milk coming out, Mrs. Williams?" I'm thinking, wow, what a thing for a kid to say. Obviously, being African American made sense. I mean, why wouldn't a kid think that? So that was one of the earliest impressions I had of Matt. And as he got a little older, I would take him sledding in the wintertime, and we had fun doing that. And would see him, obviously, he was always at the house. I mean, we lived 2 or 3 doors down from the Terrys, and there was other kids on the block, so it's a young kids' neighborhood. Everyone's around the same age, so Matt and Luke, back and forth. My wife was, I consider like the Kool-Aid mom on the block, and they would once sort of congregate, then they would hurry down to the Terry's house, so it's just a back and forth kind of thing. And those were the early impressions, basically, of just Matt just being a youth and enjoying himself.
Talk to us a little bit about Matt's relationship with your sons, like the Terry sons with your sons, and how that developed.
Again, Matt was in close age to my oldest son. Benji was born in 1972, so Benji was about 3 years older than Matt, 3 or 4 years older than Matt. So, and that's who Matt would associate with, 3 and I guess basically 3 and 6, 3 years apart. As they got older, I mean, my son and Matt saw less of each other, but his younger brother Luke and Chris developed a close relationship. So Matt was in the area, but it was more Luke and Chris kind of relationship, but Matt was always around, and he was just a brother kid.
What are some of the qualities that you noticed in Matt as you got to know him over the years, and as you grew closer to each other and your families grew closer to each other? Talk to us about some of those qualities.
We moved in the neighborhood, the Bailey Community System, in around '78. But I believe the Terrys initially moved away from East Lansing in '81. And then moved back to like '89, so there's a big gap there. So when we acquainted ourselves with the Terrys once they returned to Lansing, or East Lansing, Matt was obviously older, 10-ish, I guess. And I recall as he got older, he became more involved with computers. but I'm thinking he's a teenager by this time. So he was always over the house helping us with our computer problems. I mean, I was not good with computers, and Matt was really good at that. And he would fix whatever was wrong, bugs or whatever, and he never asked for any money, but I always sort of insisted he take the money because I told him, I said, if I had to go to a big box store to get this thing fixed, I would have to pay them. So he reluctantly took money from us. So that's primarily how we kept in touch with Matt, other than going to Christmas parties or Halloween parties or bake-offs that his parents would have at their home. So Matt was sort of around in those instances where we had those special activities.
Even when you guys would get together on occasion over the years, all the way up until 2016, 2017, did you ever see anything in him that caused you any concern that he was not a good person, or that he lacked some trait or personality trait that caused you any concern about him being around you, being around your children, being around people you care about? Was there ever any concern about that over the years?
No, it was not.
And what were the assurances that you had, or the confidences that you had in his personality or his character? You know, what did you view in him as worthy? What did you view in him as something that you wanted to be around?
I never knew him to be anything but authentic. I did not question anything that we shared together at that time. Again, it was just mostly dealing with computers, but we got into some light conversations, but it was nothing heavy. The one thing I do recall is when he did return to East Lansing in '89 beyond, in my opinion, he did change. He became a bit more quiet and into himself. I just took it as him being older and maturing, but I did remark to my wife several times that the light in Matt's eyes seemed to have dissipated. I mean, the lust that I remember him as a kid just seemed not to be there anymore. So that's what was striking to me. But again, I just sort of assumed because he's gotten older, he's matured, and maybe he just became less outgoing. But again, that was like night and day in my opinion when I reacquainted myself with that.
Over the years, you never witnessed or observed in him anything that was either callous or mistreating other people?
No.
He was never rude or unkind towards you, or?
No, never.
Did you ever see anything in him that was disrespectful towards his parents or his family in any way?
Never.
So other than the fact that maybe he had lost a little bit of that youthful enthusiasm or childhood enthusiasm, doesn't necessarily mean that he was no longer a good person.
That's true. Yes.
All right. So that never changed. Is it safe to say that has always been a consistent, that no matter when you're interacting with Matt, how often you're interacting with him, you never thought him anything less than a good person?
That's true.
And do you love him?
Yes.
And when you look back on raising your children and enjoying the love and affection of friends, you consider Matt a big part of that?
Yes, I do.
And Mr. Williams, you understand why we're here today?
Yes.
And you appreciate the decision that this jury has to make?
Yes, I do.
Pass the witness.
Hi, Mr. Williams.
Hello.
First trip to Florida?
Second trip.
Okay, well, hopefully the weather is okay. I just want to ask you, and before I do, I just want to kind of separate terminology. I know that you love Matt, okay? But I'm asking you about your opinion that he's a good person, okay? Is that the same thing in your mind, or are those different things in your mind? Can you still love a person even though they might not be a good person?
I think you could, yes.
Okay. So you talk about, you knew Matt as a kid. He was a Dennis the Menace type. It's a very descriptive way of describing a kid. He was a good kid.
Yes,
Okay. Was a good kid. That's the word that you use. Now he gets a little bit older. He's a teenager. Something is different, right?
different in the sense of,
The light in him went out. That's the way you describe it.
yes, I did.
Okay. And that's not to say he's a bad person.
True.
You said that you thought at the moment, you thought he was just growing up. He was maturing, right? Some of that youthful exuberance gives way to a little bit of maturity. You certainly didn't think anything was wrong with him, right?
That's correct.
Okay. You still love him. You still think he's a good person.
Yes,
All right. Then you discover that he attacked his girlfriend with a knife in the throat. You still love him?
yes.
You still think he's a good person?
I was shocked when I heard what happened.
I'm sure you were shocked. That doesn't answer my question. And I'm talking about Lansing, for the record, not Tampa. I'm talking about he gets arrested in Lansing. He goes to court in Lansing. He gets convicted in Lansing of attacking the mother of his child in the neck with a knife. I'm sure you still love him. You seem like a loving man. Is he still a good person?
At that point, I was questioning this person who I didn't know at the time.
You didn't know him anymore, right?
I didn't think I knew him.
And you haven't seen him since December of 2016, so you really can't tell us anything about who he is now, and certainly not who he was in May of 2022, right?
Correct.
Thank you, sir.
Mr. Williams, when the 2017 incident happened, if we can agree that Matt was born in 1975, in 2017, is it safe to say that he's 42 years old?
Yes.
Okay. Now, had you any cause to believe during the first 42 years of Matt's life, and if you met him when he was about 3, so that means you've known this man for 39 years, right?
Correct.
Okay. Did you ever get the impression during those 39 years of knowing a person that you thought of as a son, that you considered a part of your family, did you ever have any reason to believe that there was something about him that had been concealed from you, some flaw in his character that had ever been concealed from you that you never picked up on before that happened in 2017?
No.
Now, you said you've been married for 53 years, 52 years, 52 years. Is there anything about Mrs. Williams that you believe you do not know?
I don't believe so.
Okay, right. And 39 years is a long time to know somebody, even if it's, would you agree, even if you're only meeting them, or even if there's a period where you don't see them very much, like if somebody goes into the Marine Corps. When he came back from all that, did you still feel as though he was Matt?
I did, yes.
And even up until 2017 or 2016, when you're spending time together as a family, and you're seeing him for holiday occasions, and maybe you're meeting Michelle Rogers, was he still Matt?
He was still mad, yes.
Nothing further.
May this witness be released by the defense?
Yes.
And released by the state?
Yes, Your Honor.
Thank you, sir. You may step down. You may be released as a witness at this time. And I'll ask the defense, please call your next witness. Yes. Deputy Machado, good afternoon and welcome. If you'll come forward to be sworn, wherever you're comfortable, if you'll face me and raise your right hand, please. Perfect. Do you swear affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable. The microphone in front of you is fully adjustable. You may proceed.
Thank you. Good afternoon, Deputy.
Good afternoon.
And step a little bit closer to the microphone, please. And if you could identify yourself, we'd really appreciate it.
Good afternoon.
And your name?
Deputy Machado.
And, tell us your occupation and where you work.
I work at Funkborough Jail, Fort Bravo.
Okay, in what capacity?
Capacity of between 70 and 72.
No, I'm sorry. Tell us about your job.
So,
What do you do there?
as a detention deputy, I have care, custody, and control of everybody. So my job is to make sure everything is going smooth, no problems, and control everybody.
Okay. And that's obviously your job is you're a jail deputy.
Yes, sir.
Okay, so you're sworn law enforcement, and you work at the jail, which is run by the sheriff's office.
Correct.
And in that capacity, you run the pod. I think you said Fort Bravo.
Yes,
And
sir.
tell us what Fort Bravo is.
So Fort Bravo is a pod between 4 units. So one housing unit has 4 units. Alpha, Bravo, Charlie, and Delta.
Yes, sir.
So I am in charge of Fort Bravo.
How many inmates would you say are on average in one pod?
On average, around 65.
And during one shift that you have, how many jail deputies are in the pod during one shift?
One shift is just one deputy.
So you're one deputy among 65 inmates.
Correct.
Is this general population, or is it segregation, medical? How is this classified?
General population.
In general population, can you tell us what general population is like and for Bravo?
It's a little bit, I want to say it's a little bit of everything. You have your people that don't speak, people that make friends. It's a little bit of everything, a little bit of mixture of everything.
All right, so you have your guys who are troublemakers, right?
Yes, sir.
And you have your guys who keep to themselves.
Yes, sir.
You also have your guys who are helpful. Yes?
Yes, sir.
Would you say that you have guys who that you trust you're not going to have a problem with?
Yes, sir.
And then you have your guys who you probably have to spend more of your attention on during your shift as opposed to some other guys.
Correct.
Are there parts of your job that are dangerous?
Always.
Now, if you're deciding whether or not you're going to be paying attention to one inmate over another inmate, what are some of the things you might consider?
How they act, who they talk to, and who they are around.
Do you know Matthew Terry?
I did.
Do you see him in the courtroom?
I did.
Can you point him out?
Right there?
Record reflect that he's identified Mr. Matthew Terry. Tell us about your interactions with Matt.
So he is my pod trustee. A trustee is a person who cleans up after everybody's done. And he is my night trustee.
What does that mean?
So my night trustee is a person when everybody's off lockdown, they sweep the floor, mop, clean the tables off.
Your view of let me back up. How long have you known Mr. Terry?
Around 4 months now.
Do you see him every day?
I do.
Tell us about your shift hours and how many days a week you work.
So we are off 2 weeks. This is my short week, Wednesday, Thursday. My long week consists of Monday, Tuesday, Friday, Saturday, Sunday.
So you see him for about 12 hours per shift?
Yes.
And that's going to be 15 days a month?
Yes, sir.
All right. During that time, so you've seen him, you've had the opportunity to observe him safely over the course of 60 days for 12 hours a day?
Correct.
During that time, during those 60 days of observation and awareness of Mr. Terry, for 12-hour periods, have you ever had to correct his conduct?
No, sir.
Have you ever seen him engaging unpleasantly with another inmate?
No, sir.
Has he incurred in that time any disciplinary infractions?
No, sir.
What are the criteria for becoming a trustee?
So you have to have no written ups, and you have to go by classification. Classification is the persons who say yes or no.
Is it unusual for a person in Mr. Terry's status, legal status, to become a trustee?
No.
Is it unusual for an inmate who you've observed for 60 days or for 12 hours a day to not have one concern?
No.
And so Mr. Terry is conducting himself as he should conduct himself.
Correct.
And you have not seen him engage in any sort of violent behavior?
No.
Has he been helpful and cooperative in his conduct?
Yes, with other trustees, they do all the job correct.
Sir?
When he works with the other trustees, everything is done on time.
Now, much of your job is observation, obviously, right?
Correct.
You have to be able to pick on very subtle behavior to see whether or not it's presenting a danger or a risk to yourself or other inmates.
Yes, sir.
So in your job as a trained observer, in your professional opinion, do you believe you have an accurate idea of the kind of inmate that Mr. Terry is?
Yes, sir.
Court's indulgence, please. Pass the witness.
Please forgive me. I'm not trying to be unrealistic. I understand the perils of your job, but the assumed rule, the default is supposed to be people in jail are supposed to behave, right?
Correct.
Just like people out of jail are supposed to behave, right?
Correct.
There's not like you're in jail, so we give you some pass to commit crime in jail, right?
Correct.
If you misbehave in jail, whether it's a crime or it's just doing something you're not supposed to do that's not actually a crime, you get punished, right?
Yes, sir.
The reward for behaving is not being punished, correct?
Correct.
So there is a natural incentive to want to behave, correct?
Correct.
Thank you.
Redirect.
Violence is not uncommon in the pod?
No.
Violence is not uncommon. In the pod, it can be very difficult at times to get along with other inmates, can it?
Yes, sir.
Tell us about some of the challenges that some of these inmates are going through with either drug withdrawal, stress of legal proceedings, not getting along because of gang warfare. Tell us about some of the risks that are posed within that pod that we may not experience in everyday life.
Your Honor, I would object as to relevance for what other people are going through.
Go ahead, please.
So, like I said before, many inmates in there are in there for different charges. So as well as nobody is going to get along with everybody. There you have some of your people that are young, that those stick together as one. Then you have their older ones that they just go by their day.
And what are some of the challenges that you encounter in having to supervise this population of guys that say we might not encounter in this courtroom? Gang warfare?
Yes, sir.
People trying to smuggle in weapons and drugs?
Always.
Always. Temptations,
Yes, sir.
short tempers,
Yes, very.
people testing one another,
Always.
people testing you,
Always, yes, sir.
things that we don't necessarily encounter every day on the street.
Correct.
That an inmate who wants to keep to himself and be trustworthy must avoid on a daily basis.
Correct.
Avoiding temptation,
Yes, sir.
avoiding conflict,
Yes, sir.
while also in his status at not having an end of sentence date continues to be a trustee with no benefit to his sentence, correct?
Correct.
Nothing further.
And is witness be released by the defendant? Released?
Yes.
And released by the state?
Yes, Your Honor.
Thank you, sir. You may, deputy, you may step down. You may be released as a witness at this time. I'll ask the defense to call your next witness. Jamie Robertson.
Ms. Robertson has difficulty hearing. Is there a hearing assisted device that we can give to her? That may...
No.
No? Okay.
We can talk louder.
Right this way. Just stand right here and face the judge.
Ma'am, good afternoon.
I'm sorry.
So you need me to talk really loud?
Yeah.
Okay.
Yes.
We'll see if... How's this?
That's good. Thank you.
All right. I'm going to swear you in, ma'am. If you'll raise your right hand, please. Right hand, please. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Have a seat. Make yourself comfortable. I'm going to ask you to get close to that microphone. Mr. Kane, you're going to have to use the microphone at that podium.
Does amplify. Okay. Good afternoon, Ms. Robertson. Can you hear me okay?
Yeah, I'm going to have trouble hearing you.
Okay.
Got to speak louder, Mr. Kane.
All right.
Yeah,
Give it a shot.
sorry.
All right. Is that better? All right. Ms. Robertson, can you identify yourself, please?
Can I what?
Can you identify yourself? Your name? Can I move closer to the podium?
You can get as close as you want, but you don't have a microphone.
I'm not going to be able to hear you.
All right, Ms. Robertson, can you identify yourself?
Jamie Ann Robertson?
Do you know Matthew Terry?
Yes, I do.
Can you point him out?
He's right there.
Let the record reflect that Ms. Robertson has identified Mr. Terry.
The record shall so reflect.
Ms. Robertson, can you tell us how you know Mr. Terry, how you know Matt?
Well, Matt is my firstborn nephew in our family. I have a lot of them, but he was my firstborn one, sort of my special guy.
Tell us about your relationship with Matt.
Oh. I was around Matt a lot when he was a baby. And then as he got a little bit older, we got to have sort of a special relationship. We did things together. We went shopping for his birthday presents together. We spent our summers at our cottage up on Big Blue Lake. We spent our winters up at the cottage at Big Blue Lake, fishing, swimming, water skiing, just everything. And he and his brothers and my 2 children and my sister's 2 boys, we all had just a nice life, a nice family. Actually, one of my very best friends was Matt's first kindergarten teacher, Mrs. Hart, and she remembers Matt. And we would talk about the kids in school. Matt was a very smart little and young man and grown man. He was very had a good sense of humor. He was a very enthusiastic child. He was very curious. He liked to do things. He liked to go to the museum. He liked to stand in the dock and fish. He liked to know about everything. And he grew up that way. He grew up being very concerned about conservation, about the country. His family, he loved his family. We all had a very close relationship with each other, and we spent a lot of precious time together. Family, birthdays, and Christmas and holidays, etc. And then as Matt got a little bit older, he graduated from high school. And during that time, I think he probably was just a plain old regular teenager. I'm sure he got into trouble and probably got bad grades, but so did the rest of the guys in the family. So he was just sort of a normal young man. He made us all very proud, especially my grandfather, by going into the Marines and coming home in his uniform, I think ready to take care of the country and take care of everybody. He really firmly believed in what he had learned during that time, and I believe represented them very well, even after he was out. Am I saying enough here?
I appreciate it, Ms. Robertson. You had described your relationship with him as somewhat special, and that you and Matt had a bond that perhaps he may not have had with your other nephews or nieces. Can you talk about that?
Well, you know, those things just sort of grow. They just sort of happened. And I had 2 older children, and they liked to take care of their cousin Matt. And so Matt went with us and did things with us. And he was the oldest of the 3, and we just happened to be together when he was growing up. And I don't know how to really talk about it anymore, except we were just, I always felt close and kept track of each other. I lived away from everybody for a lot of his growing up years, so when I was there, I would check in with him and do special things with him. He was just special to me.
You know that he has been convicted of first-degree murder.
Yes, I do.
And you know that your testimony is here to give the benefit of more information to the jury so that they can make a decision on whether or not Matt will receive the death penalty or receive a life sentence in prison. You understand?
Yes.
So, in your observations of Matt over the years, from when you first came home from the hospital as an infant, all the way up until the last time that you sat down and you spent quality time with him, and you looked at him and you had a conversation with him, what are the qualities that you noticed about him that you felt really close to?
Well, he loved to read books, and I loved to read books. He liked to go to the library.
Now, those are activities. Those are activities.
What do you want?
What are the qualities? The qualities about him as a person.
I think of Matt as being very kind, very conscientious to his family, the outdoors, his friends, and school. He was enthusiastic. He was active. And I don't really felt that he had a temper. I think sometimes we would have to set him down and tell him that he had to wait for a few minutes until he continued doing what he was doing. But he didn't get angry. The three boys all had qualities of being happy young brothers, and I think Matt was a happy brother to his other two. He took care of the younger ones, and I think they looked up to him. I think they looked up to him as being wise. He was wise. I think, and he cared. He cared about his parents and his family, and God, and nature, and very much, nature and the earth. His quality. He was a really fine young man growing up in some years that maybe there were a lot of different attitudes and stuff out there. I think Matt just came through with flying colors. I think he...
Can you tell us about the challenges that he had with Jessica?
I'm sorry, what?
The challenges that he had with Jessica?
Okay, Jessica. Jessica was a lot like her dad. She was very inquisitive, very wise, very active, very happy, but Jessica did have a mind of her own. And I think for Matt, he struggled sometimes with that, knowing what was the right thing to do with her, and asking questions and needing some guidance, raising her. She was a handful. And she visited between Matt up in Michigan and her mother, Nikki, down in North Carolina. So Jessica could have the best of both of them, and she took advantage of that.
Course indulgence, please.
Sir?
Thank you.
Mr. Diaz, cross-examination. Please use the microphone.
Yes, Your Honor. Is this okay, or do you want me to stand over there?
Oh, over here would be great if you could.
Yes, ma'am.
I'm sorry to have to ask for special.
Do not apologize. All right, can you hear me okay? Okay, good. You call Matt your special guy. Is that correct?
Yeah.
I mean, I would say you don't just love him, you must really love him then if he's your special guy.
Yeah, he was a special guy.
Okay. You described him as kind and conscientious. Is that a yes? You gotta answer out loud for the court reporter.
Yes.
Thank you, ma'am. You described him as having no temper.
No, I don't know that I said no temper. I wasn't aware of a real strong temper.
Okay. You talked about him being a Marine. Is that a yes? You gotta say a word out loud.
And what?
Is that a yes?
Yes.
Okay.
I'm sorry.
You have to always answer with a word.
Okay, yes.
No
Okay.
problem. Try to avoid or you said that you thought he represented the Marines well.
Yes.
And I'm guessing you were not a Marine. Is that correct?
No, but I had a lot of military families.
Okay.
So I had a,
So you know Marines are protectors.
yes.
They are defenders.
Yes.
Defenders of the weak and the helpless and against evil.
Yes.
And you
Judge,
think,
I'm going to object. Mr. Terry's service was 1993 to 1997. The first allegation of anything inappropriate occurring, or for our purposes that we're here for today, was 2017, almost 20 years after his release from active duty.
It's overruled. You can answer the question, ma'am.
so Marines are champions, defenders of the weak, the helpless, and people who protect against evil, correct?
Yes.
And you think Matt has always honorably represented being a Marine even after he quit being a Marine?
I do.
Okay. Ma'am, please understand, I derive no pleasure from upsetting you. So if I start to upset you, please tell
It's
me.
okay. No.
Do you know anything about the facts of what happened in 2017 in Michigan?
Objection. Relevance.
Wait.
With
Wait.
Michelle?
Overruled. You can answer, ma'am. Go ahead.
Yes, ma'am, with Michelle.
Yes, I do. Yes, I do.
You know that he stabbed the mother of his child in the neck with a knife?
Yes, I do.
You think that that is kind and conscientious?
No.
Do you think that that indicates he doesn't have a temper?
I suppose you would call that a temper, yes.
Do you think that that is representative of what a Marine should be?
Probably not.
Okay. How much do you know about the facts of this case, the one from Tampa?
Enough, yeah.
Do you know the injuries that Kay Baker suffered?
Yes, I do.
You know that her head was cut halfway off?
Yes.
You think that is kind?
No.
You think that is conscientious?
No.
You think that is an indication of no temper or little temper?
Yes, it is.
You think that's an indication that he doesn't have a temper?
Oh, I think that is an indication of some temper, some rage, of anger.
Thank you, ma'am.
Hello again, Mr. Robertson. Now, the Matthew Terry, the nephew that you've known, and you had known him, you've known him all his life, correct? Is that right?
Yes. Yes.
You were aware of some of these incidences that have occurred in 2017 and obviously in 2022, right?
Yes.
Were you aware of intimate details? Were you aware of testimony? Or were you aware of the circumstances that led to those events? Were you at all aware of those things?
No. No.
Does the little bit of information that you know affect or impact your view of Matt as a nephew of yours who you hold in a special favor? Does that affect or impact that at all?
Can you repeat that?
In these cases, does the fact that he's been convicted of first-degree murder in Tampa, or that he was convicted of aggravated assault in Michigan, does that impact or affect your impressions of him as somebody that you know and love?
Well, of course, it makes me look at things, but he's still my nephew. I still love him. I try to understand what I've heard.
And obviously, because you're a relative, that's not unusual for your love for him to persist throughout unpleasant occasions or those things that reveal flaws in us, right?
Mm-hmm.
But even though he is your nephew, or forgetting about the fact that he is your nephew, do you believe that throughout the years you have known him as a man? Do you know him as a man?
I do.
And does your knowledge of him as a man and what you believe about him have anything to do with the fact that he's your nephew? Or is that knowledge you have apart from the fact that he's your nephew? Do you understand my question?
Mm-hmm. Mm-hmm. As a man, you're asking me? I've always respected that. I don't understand these circumstances. I don't understand all sides of it. But I have always respected Matt. Is that answering it for you?
Thank you, Ms. Robertson. I have nothing further.
May she be released as a defense?
Yes.
And released by the state?
Yes, Your Honor.
Thank you very much, ma'am. You may step down. You may be released as a witness at this time, and please, ma'am, watch your step.
Let me have the attorney's approach, please. Consulting with the attorneys, we are going to call it a day. It's a little after 5. I know I had told you to prepare to go late, but we're in good shape. I do want you to still be prepared tomorrow just in case, but I'm going to send you home for the day. Please, my prior restrictions all apply. Do not do any research related to the case. Do not discuss the case amongst yourselves with anyone else, and please avoid any reports of the case outside of the courtroom. Please have a safe trip home and a safe trip back in the morning. I'll see you. We'll start at 9 a.m. All rise for the jury. Jury has exited. Everyone may be seated. You're coughing.
I know, we all started coughing.
I know.
Judge, per the defense's request, I did burn a copy of the phone call. I gave a copy of them already. This is the copy that I would... That the
Court's
defense wanted to
exhibit
see.
number 5, did we say?
Yes.
Madam Clerk? All right. Go ahead and hand it to the clerk.
I don't have a number.
Oh.
I'm so sorry. If we can get you one. They didn't bring me one.
Anybody have an extra envelope? CD envelope? Sleeve? Yeah, I guess.
I'll just give her this one.
Oh, we got one.
Give her when I get back to the office. For
All right. And that is officially court exhibit number 5. All right, so anything before we break for the evening?
No, nothing further, thank you.
State?
No, Your Honor, thank you.
All right.
Your Honor, I guess just looking ahead, do we think that we're going to be doing closings tomorrow? I'm just trying to plan accordingly.
It depends on what the court's schedule is gonna be, what's the court's thought process on that?
It
You know, a lot of
depends.
times right, a lot of times in the death penalty cases, we do first thing in the morning to give them as much time as possible.
I prefer that.
But
I know that we
finish at
have,
lunch, I don't know how you're gonna feel.
We may be finished.
but the problem with that is then we would do the closings after lunch, so we would send them out late. We have to secure hotel rooms if they want to, if they go long. So I would prefer that if we're not getting to closings in the afternoon, that we come back Friday morning, we do those first thing in the morning, and we get them out deliberating before lunch on Friday.
And I'm just trying to understand what Your Honor is saying. So
What was
again,
difficult about that?
I'm not holding the defense to anything, but it sounds like they think that they might even be done by lunchtime.
That's what they said, I think.
And so, if we do get done with defense case by lunchtime, and I don't anticipate any rebuttal, we could be closing at like 1:30, 1 o'clock, which means we could have a jury ready to deliberate by 3:30. Is that going to be too late in the day?
I would prefer to bring them and begin deliberations in the morning, given the potential of the sequestering the jury.
So would Your Honor have us do closings and then send the jury home after closings to just come back in the morning to start deliberations? Or are you going to postpone closings as well until Friday morning?
I was going to postpone closings, but I suppose there's a possibility of doing the closings tomorrow, instructing them not to begin deliberation and come back on Friday to deliberate.
Yeah, we still do the jury instructions also. So,
Do you anticipate any lengthy issues? We could do that over lunch.
Yeah, I mean, the instructions are like 6 pages long. They're not that long. And
we have to do the mitigating circumstances.
I tell you what I'm going to do. I'm going to tell you all to be prepared
yes, Your Honor.
to do closing. And then if I decide, depending on the time tomorrow, that we're not, then you get the benefit of extra time to prepare. But there is a possibility that I will do closings, send them home, and tell them to come back first thing Friday morning to begin deliberation.
But then when would they be instructed? And so that's the whole issue, is when would they be instructed, and that, when the closings are, and the sequestration, you know what I mean? That's where it rubs.
No, I hear you. I hear you. Be prepared to do closings. We can discuss those, whether I instruct them before I send them home, or whether I bring them in Friday morning and instruct them. We haven't even discussed whether we instruct before closings, which is a possibility. So assuming that's what we decide to do, we will go over jury instructions during lunch. I may instruct them after, allow closing arguments, and then tell them to come back Friday morning for deliberations. Go off the record. Be prepared to do closings tomorrow. And if we don't